All right, and ask all Rules Committee members to take their seats. There's all right, I'd like to start with the Rules Committee. All right, Mike, could you call the roll, please?
For the Rules Committee, sir.
Yes.
Roll call. Legislator Sela Bino. Legislator Delia DeRicci-Witten. She's in the building, correct? Yes. Ranking Member Kavan Abrahams. Substituting for Legislator Laura Schaefer is Legislator Denise Ford. Legislator Stephen Rhodes. Thank you. Vice Chairman Howard Copel. Chairman Richard Nicolello. We have a quorum, sir.
Thank you. We'll start with the contracts portion of our meeting, and I'm going to call the contracts together at this time. 830, 838, 839, 840, 841, 842. These are resolutions authorizing the Commission of Shared Services to award and execute blanket purchase orders between the county and Mensch, Mill, and Lumber, L.I. Proliner, We Transport, Inc., Educational Bus Transportation, Inc., Guardian Bus Company, Inc., L&M Bus Corp., B19, B25, B26. These are resolutions authorizing the county executive to award and execute contracts between the county and the Land Tech Group, 192 Branch Services, RJ Industries, Inc., E99, E100, E101, E102, E103, E104, E105, E107, E108, E109, E110, E111, E112, E113, E114. These are all resolutions authorizing the county executive to execute personal services agreements or amendments to personal services agreements between the county and DMB Engineers, Gannett Fleming, Jackson Lewis, H2M Architects, WSP USA, Sokoloff Stern, West Group Law, NASA Healthcare Corporation, Montfort Healy, Lewis Joes, the lower office of Vincent McNamara, Bond, Shenick and King, and Leahy and Johnson. The last two involve E106. It's a resolution authorizing the county executive to execute an amendment to a license agreement between the county and Carlton on the Park. E115 is a resolution authorizing the county executive to execute an amendment to a license agreement between the county and National Development Council, moved by Deputy Presiding Officer Copel, seconded by Legislator Minority Leader Abrahams. Okay, all of the contracts are now before us. Let's start off with A30, 2021. It's a contract with Mensch, Mill, and Lumber.
Good afternoon, Ken Arnold, Public Works. A30 is a service contract, a materials contract for drywall and studs to be used by our facilities department as part of their normal work and also on the capital improvements. We had 4 vendors bid, and Menschleber was chosen as the lowest responsible bidder.
Any questions? No? I guess you'll be back later. Okay. A38, Police Department and Proliner, Inc.
Good afternoon, William Field, Inspector of the Police Department. Item A38-21 is to authorize and award a blanket purchase order for ambulances for the Nassau County Police Department's Emergency Ambulance Bureau. 4 vendors bid on this solicitation. The lowest responsible bidder was LI Proliner. The maximum amount authorized under this blanket purchase order is, with its renewal options, is $15 million. The period shall be from 1 year from the effective date, with a total renewal options to be 5 years and 2 months.
How many ambulances will the county get? How many ambulances will the county get as a result of this contract?
So it depends on, so for new purchases, they're about $205,000 about, and then with having to do repairs as well, they can amount to, it depends. Every year it can fluctuate based on needs and maintenance and things like that.
Okay. Any questions? No. All right, thank you.
Thank you.
All right, next, contracts are with the health departments. I'm going to ask, we consider 4 together. Those are A39, A40, A41, and A42, involving transportation for preschool education.
Good afternoon, Mary Ellen Lorraine, Department of Health. These items are a blanket purchase order for the transportation of Nassau County children in the special needs and preschool early intervention programs. This is mandated under public health law that we provide this transportation. There were 4 bids. All the companies received, were awarded a contract.
One question I have, Mary Ellen, is that the first 3 of these contracts, we transport educational bus transportation and Guardian Bus Company. They all, each one of them, bid on a zone, and they were the only bus contractor to bid on a zone. So, I mean, I find that a little unusual that the other contractors aren't all bidding together to get these different zones, but instead you're just getting one contract, at least for the first 3, for each zone. Do you have any reasons to why that occurs?
I'm just going to ask Robert Cleary because I wasn't a part of that discussion.
Okay.
Robert Cleary. To my knowledge, that question wasn't asked specifically, although I did notice that as well. My experience is that those vendors were playing to their strengths. They were familiar with those routes. Those are incumbent vendors, and they apparently were interested in those particular routes and not the others. As I said, I at least have not asked that question. I don't know if purchasing did or not, but I hadn't heard that they had. They were all eligible to participate in any one of those zones, obviously. They could have responded to all of them, any combination of them. But this is a business that they have the infrastructure for, they have the buses for, they have the experience in, and for whatever reasons, those are the businesses, those are the routes that they chose to participate on.
And it also complements some of their other schools that they also transport for.
Okay. I mean, those seem like possible answers that they're incumbents, they're already servicing those routes or have been in the past, and they cover those routes for their other school districts that they work for. I mean, the concern I have obviously is you want as many vendors bidding on these routes as possible because there's a better chance you'll get a lower bid. I mean, in terms of the cost of this. So, and Mr. Cleary, there was no so there was no questioning of this in terms of when these were considered. Is that correct?
Not to my knowledge. I will say this: the bid structure was changed slightly from the last time that this was solicited, precisely to encourage people to participate. Rather, encourage vendors to participate. So this was actually, I think, structured to be a more potentially competitive solicitation than it was 5 years ago.
Okay. Any other questions on these four? I mean, I honestly, I think I might ask the Inspector General just to take a look at this again. Just, this may be, as you suggest, having to do with their familiarity with routes and the fact that they're providing these services during the school year to the school districts in those same routes. But I think I'd just like to ask them to take a look at this anyway. But I wouldn't hold it up because obviously you have to transport these children.
Right.
So, all right. Any other questions on these four? Nope. All right, so while you're here, why don't we go to number 108, which is with Nassau Healthcare Corporation.
Yes. Item E108 is an amendment to Amendment Number 4 for a contract with Nassau Healthcare Corporation. It's the amount of $5 million. It's for our mandated public health services pursuant to New York State public health law. As you may know, in 1999, the Public Benefit Corporation was established, and our clinical health, which the clinical health was a part of the health department, became part of Nassau Healthcare Corporation, and since then they have been providing these services.
Okay. Any questions? Okay, thank you.
Okay, thank you.
Next contracts are with DPW, starting with B19 and the Land Tech Group.
Ken Arnold, Public Works. B19 is a construction project for Centennial Park in Roosevelt. This is for our rehabilitation of the complete park facility. There were 9 bids received, and Land Tech, with a bid of $3.3 million, was the lowest responsible bidder. It was below the engineer's estimate. The project was partially funded through some CDBG funds we received. MWB participation is at 4%.
Yes, sure. Minority Leader Abraham.
How are you, Ken?
Very good.
Just a quick question, if you can share with us, just for the record, the scope of the project and when the contract would allow the project to actually commence.
So the scope of the project is to redo most of the park. I think the only area that we're not reconstructing are the basketball courts. We are putting in we're taking out a big sitting area that's become problematic for the park operation, and we're putting in some youth areas for soccer playing. We also are redoing the spray park. We're cleaning up the admin building. Park paths are getting redone, along with plantings, and the playground is getting refurbished in totality.
Are we resurfacing the courts?
I'd have to double check. I forget how we left that.
I think we should take a look at that because the
Yeah,
courts
at the top of my head, I'm resurfacing courts all over the county, so I can't.
Okay.
I don't know if
Because
that was.
the courts are a bit in disrepair.
Our intent was not to leave anything in disrepair when we left, so.
Okay. And when will the contract allow everything to commence, and what's the duration of that
So
construction or renovation?
my goal is to get this contract approved so we can have a September start, so I can close the job down. The park has to be closed during construction. It's going to be closed for 1 year. That's the duration of the project.
I remember that.
So I'm hoping to start it this winter, so I get a good winter season of closing it down. So I'm ready to open by the following September, or if we get done a little earlier before
Okay.
that.
If you could just work with my office to ensure that the public's properly notified, so nobody comes to the park and then sees everything ripped up.
Yes.
We'll work with you to ensure that the park, everyone around there is properly
Right.
notified.
And my time is contingent on getting controller and knife for approval and everything.
Understandable. Okay. I have nothing further. Thank you, Ken.
There you go.
Okay. Any other questions on this one? Next one is B25.
B25 is a contract amendment for 192 branch services, environmental services. It's associated with the lead remediation at the Mitchell Field Military Housing. We are adding $6 million in their contract to cover the removal of lead and the refurbishment of the units where the lead abatement was taking place.
Okay, Deputy Presiding Officer Coppell.
Ken, this was originally a contract for $1 million,
Correct.
and you're going out to $7 million now, and you're not rebidding it.
The reason that we did not do that, I know that's a concern of yours, we've talked about
It's
this.
a concern. As a matter of fact, I wanted to say, I want to thank Katie, who's been working with me on this. And I know she's been promised by various people in the administration. I think that's not even your department generally, but maybe purchasing generally is supposed to come back with some sort of policy. And this has been going on for months. So maybe this is an outlier. Maybe you've got a good reason for this particular one, but this is a recurrent problem here.
Right. So when we bid our on-call contracts, on occasion, we have a very large scope that comes up, and for timely satisfaction of getting this work done, to go out for a rebid, our rebidding process is 9 months. So it was the department's decision, talking with the administration, I think, and this had to get done within 90 days of issuing reports, that we had to issue an addenda and just increase the bid amount for this work.
You see, but with all due respect, I don't really understand how that necessarily works. I mean, if this is something that was urgent, we perhaps first could have started the process a little earlier on one hand, or perhaps could have done a small extension. But this is not really an extension. This is going from 1 million to 7 million. I mean, essentially, people who bid, we went out on a bid on 1 million, and you're going to get one kind of bidder perhaps, but when you, as you know, you're going to get often you're going to get an entirely different class of bidder perhaps when you're going on a much larger contract. And I think we're potentially shortchanging ourselves constantly. So I don't see how this makes sense.
Well, but this work has been going on since July, so.
Is it one discrete project?
Yes, the Mitchell Field remediation started in July, so it's been.
And this is the kind of.
Not July.
This is the kind of project where going from one vendor to another would be disruptive? Or is it, they're doing perhaps different areas at different times?
Would it be disruptive? I'd have to think through all the different components. We're working towards we did the environmental work, issued reports. Anybody with kids under 6, we have 90 days if they're getting federal subsidies to get their work done. So that was the first impetus of getting the work done. Could we brought another vendor in? We could have, but it would have been disjointed to have multiple vendors on the same property. We're having a difficult enough time coordinating with the tenants as it is.
Or for that matter, a new vendor. Let's say this vendor stops in 2 or 3 months. They're finished with their contract. Mm-hmm. You have a new vendor come in. That would work, wouldn't it?
Yes, we're also looking to try to get this work done before the end of the year.
No, so. I hear you. I hear you. This just, as I say, this kind of thing is it's circumventing the entire bid process. The whole bid process is there for a reason, and this just avoids it. And it's a really, again, with all due respect, it's a bad way to do business.
I understand your concerns.
Anyone else? All right. Let's move on to the next one with RJ.
Okay, so B26 is a construction contract for the improvements to the preliminary treatment system at the Glen Cove Treatment Plant. There were 8 bids received, and RJ Industries determined to be the lowest responsible bidder. The bid of $6.2 million was below the engineer's estimate. Their MWVE participation is 29%.
Are there any questions on this? B26? None. Move on to the next one, please.
E99?
Yes.
So E99 is a professional services contract for the study to look at the feasibility of sewering the Point Lookout community. That is one of the 2 last communities on the South Shore that are not sewered, the other being a small portion of Lawrence. This project is the 3rd piece of the Western Bay Initiative, where we're looking to improve the quality of the bays by the removal of nitrogen, which the septics at Point Lookout would contribute to that. We had 5 bids received. D&B was technically ranked very high and included the lowest cost proposal. The Technical Review Committee selected D&B as they were the best value for this project. The MWB participation is 40% for D&B.
How long, Commissioner Arnold, how long will this, do you think the study will take?
I don't have the contract in front of me. I'd have to look. There's a timeline in the contract once they start, so I can get that information to you. And there'll be community meetings and all kinds of steps that we would go through,
Yeah, 'cause
working
I-
with your office.
Yeah, because I probably will try to schedule one rather soon so that the community will be aware that we are continuing with this. And I want to thank you very much,
Okay.
you know, for staying on top of this because it means a lot to the residents up in that area. So, you know, so I'll be in touch. But
Okay.
if you can find out like how long the feasibility and then with other timelines, once the study is done, if the residents go
Yeah.
along with this,
Well,
what the next steps would be.
I'll set a meeting up with your office so we can go over the project.
Perfect. I thank you very much, sir.
I think this is an excellent project, and I always love sewers, as you know, Ken. However, we were notified by the Inspector General that there's an ongoing investigation and that they need some more time. So we're hoping it's going to be done very quickly, but we just need their report once we're put on notice. We really
Understood.
have to get
That's
a
been,
report.
that's
So,
been,
Denise, again, as much
the
as I
policy
hate
of
to
the-
delay anything, but I have to, I'm going to make a motion to table.
right, that's been your policy, though, to get that report, so I understand.
Okay.
Okay, we need a second?
Motion to table.
Second by legislator Bino. All in favor of tabling, signify by saying aye.
Aye.
Those opposed? All right, the item's tabled. Gee, I know. Let's see. Okay, 100
Okay.
with Gannett Fleming.
So E100 is the construction services contract associated with the Glencoe Preliminary Treatment Project I just mentioned earlier. For this one, there were 7 proposals received. The three highest qualified firms had their costs looked at, as they all were deemed to be able to do this job successfully. Gannett Fleming had the lowest cost at $1.29 million and was selected. MWBE's at 20%.
Any questions? No. All right, 102.
E102 is the last of the 5 firms that was selected for the building on-call design contracts. The other 4 went through the last session. This contract is with H2M, and the MWB will be determined based upon the task orders as they're assigned.
Any questions? All right. E103.
I'll bring up Sean Sally. He can speak to this one item.
Sean Sally, Nassau County Department of Public Works, Deputy Commissioner. This is a proposed contract amendment with the firm of WSP, formerly Parsons Brinkerhoft. WSP currently performs planning, management, and technical support relating to the Federal Transit Administration FTA grant-funded Hub Transit Alternatives Analysis Project. The contract amendment proposes 3 amendments to the current term. The first being an extension of the term. The second is a reallocation of existing budget. And the third is an additional budget, or increasing the maximum amount payable by $2.5 million. This work is funded through 2 earmarks, FTA earmarks that were secured back in 2007, 2008. They are at 80% reimbursable. The FTA has been monitoring our progress over the past decade. They've been very supportive with respect to our planning process, but they also would like to see us, conclude the process. Our success is their success. So these additional funds would allow us essentially to conclude the planning process, which basically consists of a few things. It's looking at potential transit alignments from the Nassau Hub area to the Long Island Railroad main line, as well as the Hempstead Intermodal Center. The planning and financial work involved with a pilot to acquire 6 battery electric buses to be built into the NICE fleet to operate in the hub area as well as other routes in the county. And third is to do preliminary design. Once the transit alternative is selected, there is funding and grant budget to perform preliminary design to advance the selected alignment. So with that, I'll take any questions.
This is largely funded by federal money, right?
Correct, 80% from the FTA.
The study of transit alternatives in the hub has been going on for decades. So, I mean, is there a projected date in which they will have some sort of proposal to us?
There is. So we're actually under the obligation to provide the final recommendations to the FTA by September of 2022. So that is what we're working backward from.
Okay. Anyone have any other questions on this one? All right, thank you again, Sean.
Thank you.
The next contract's with the County Attorney's Office.
Good afternoon, legislators. Brian Libbert, Deputy County Attorney. Do you want to speak, or do you want to call them in order?
Let's go E101, Jackson Lewis.
E101 is a contract with the law firm of Jackson Lewis for the case of Shaniqua Bynum against Nassau Community College. This firm was selected by the college, and the ordinary procurement process was followed after that.
If it's the college who is the defendant, well, a defendant, why is the county paying or the college for the attorneys?
For the defense?
Yes.
The county attorney's office is paying.
Okay. So explain to me why is the county a defendant if it involves the college?
My understanding is that there's no mechanical means for the college to pay for counsel in this scenario. This procurement itself was done through municipal transaction. Of course, I'm sort of the litigation manager. So with regard to the payment, it's just my understanding that there's no mechanism for the college to fund that, and that therefore the county attorney did.
I don't know that I was even aware of that. I mean, that could be the case. Yeah.
My understanding is that the college had selected this firm, and that there was a discussion between the college and the county attorney's office whereby the college was unable to procure and pay for this firm, so it was done this way. That's what I've been advised.
So, does that mean that anytime the college gets is a party to a lawsuit, the county has to pay?
Well, legislator, I wouldn't speculate as to what happens in any situation. Being a learned counsel, I wouldn't make any speculation about that. I would say, their counsel should sort of say what happens in each scenario. I only know what happened in this particular scenario.
But you don't really know because you're not. Why? What's the reason for this? That what would differentiate this scenario from any others?
I can't, at this time, I can't speak to that because I'm not familiar with any other procurements that were done through the college, through county attorney. I'm just not familiar with those.
Because once again, this bypasses the usual procurement thing. In other words, the college selects it, the county pays, and what's the bid process? How does this work then?
Again, the bid process was done through the college, and
Right.
there was an agreement between the college and the county attorney's office. I certainly understand your concern about that, legislator. I would just say to that again, that procurement process was prior to my involvement, so I just wouldn't speak to personal knowledge of it.
To you personally, and will this, if it's a college matter, does the college then reimburse the county attorney?
I'm not aware of any reimbursement that has occurred at this time.
No, well, it wouldn't have occurred, but would it occur?
Not that I've been made aware
And the question is why?
Again, I would have to defer to my colleagues in municipal transactions about that. My expertise to the extent that I have any is in litigation and not in the transactional matters.
Okay, moving on to another topic on this one. I think the onset date was February 21st, 2019.
Yes. This is actually for the same reasons as just discussed. Again, my understanding is that the college selected this law firm and that there were some discussions between the county attorney's office and the college whereby the college notified the county attorney's office, we don't have a mechanism to pay for this. And that procedure on its own took several months. At the time that the county attorney's office then took it over, we needed to work with this firm to create a budget for the litigation. So there was the initial delay of the procurement through the college, and then the further delay of the administrative budget process.
Okay, just going to the aspect you mentioned of the budget as a reason for the delay. I mean, how long does it take to prepare a budget?
Legislature, I would say this and this. I can say generally, I would expect, and in my experience, that it takes about 2 weeks to 30 days is a reasonable time to produce a budget. However, prior to this contract, the county was not following this budget process. So this is all new hat for our office and for some of the firms that we're working with, and it did take longer than it does now. Our process has greatly improved.
I will have to disagree with you there. I mean, in my other life, I do work for a law firm. We produce budgets for clients. Simple case takes about a half an hour. More complicated case, a couple hours. So I don't really see that as an excuse for the delays in this matter. You know, there's a number of other contracts coming up. None as egregious as this one, but that all of them are late. There seems to be an ongoing problem with the county attorney's office with respect to getting these contracts to us on time. So I personally am going to ask, personally, as you know, in my capacity as presiding officer, I'll ask Mr. Cleary and/or the IG to take a look at the process. Obviously, it doesn't go to the quality of the legal work being done by the county attorney's office. It's always been excellent, but it goes to, I mean, why are these chronically late coming to us? Contracts, law firms being brought on, doing work for months and months, and then contract shows up with us. It's become a chronic problem.
I think, frankly, legislator, your point is well taken. We have already engaged in some discussions with, I believe it's Director Cleary, on some of these processes, and I can speak to, as you said, not my personal capacity, but what I've personally done. I have been involved with Mr. Cleary and also Chief Deputy Molinaris with improving this process, in finding where these flaws are occurring and trying to improve them. Unfortunately, there were some contracts that were back in the system before we started fixing them, and that is what you're seeing some of. So I will speak to an improvement that perhaps isn't in a day yet to come, because hope springs eternal.
Okay. Mr. Cleary, I see you're up at the mic. Oh, I'm sorry.
Good afternoon, Legislature. Chief Deputy County Attorney Jessica Molinaris. I just want to jump in here, even though Brian Lieber was doing a great job, but I do have to second his comments. We have taken back all the comments from the legislature, and we have continuously implemented improvements. We have mentioned on some of our prior contracts, this is a process that we're trying to remedy. So there are a few other contracts, unfortunately, that you're going to see such a similar situation. We have discussed this with, Compliance Director Robert Cleary. We've had meetings with him to discuss these and have brought these to his attention. This is a continuous process, but I will assure you again that my office is working on remedying this.
Thank you very much. Mr. Cleary?
Yes, Robert Cleary, I just wanted to confirm, yes, we have had a few conversations about this. It's become pretty apparent recently, and we're in cleanup mode at this point, getting our arms around what the outstanding contracts are, getting them through the process. It's not a coincidence that you've got a lot of contracts this period. And we're going to continue with that effort until we're up to date. The litigation does create a difficulty in certain circumstances where we need to bring somebody on quickly, but this goes beyond that, and we recognize that.
Okay, thank you. I appreciate the fact that you are involved, and I would appreciate if you would keep all counsel apprised of how this process is going.
Will do.
Okay. Now, with respect to this, the first one, I will take a motion to table. I think we would like to get some answers in terms of process, how it works with the, with the college, and why the college cannot, pay for their own counsel, et cetera.
Understood.
Moved by Deputy Presiding Officer Coppell, seconded by Legislator Bino. All in favor of tabling signify by saying aye. Aye. Those opposed, E101 is tabled. Okay, you want to move on to the next one?
I have E104.
Yes.
E104 is a contract with the law firm of Sokolov and Stern for the matter known as Rollins. The procurement was done previously. However, the case had never materialized. It was a notice of claim phase, and at this point, that is where it remains. So there is extremely limited outstanding invoices.
Okay. Any questions on this one? Nope. Let's go to E105.
This is a contract with the West Group for representation relative to building of the crime lab. There was a dispute with the developer, and there was a procurement by the county attorney's office relative to finding a firm who could assist with this construction management litigation.
I think the question we had, it was a little bit unclear. Is the county the plaintiff here or the defendant?
At this time, the county, it's really both. The county was initially a defendant. There was a discussion with West about the best strategy. I would just say that for purposes of the record.
Okay. Any other questions on this one? All right, 109. It's Montfort Healy.
This is a contract with Montfort Healy for the lawsuit of Salages v. Nassau County. That also did not get past the notice of claim stage.
Okay. The plaintiff is, the claimant is, what do you mean it didn't get past it? It's been resolved?
It remains in the notice of claim stage. My apologies. I should have been very clear for the record.
The claimant is the Nassau County legislator.
That is correct.
Obviously, you're sending it to outside counsel, but can the county attorney's office have any involvement whatsoever in this?
To my understanding, no. I believe the answer is no. Again, I'm loath to speak in absolutes, but I believe the answer is no.
I agree, and I believe your office is going to have an outside entity monitor this. In other words, you have outside counsel, yes, but I don't think that's enough. I don't think your office can have anything to do with this because, as with the DA's office and legislators being prohibited from working on criminal matters, this body controls the budget of the county attorney's office. So there is an inherent conflict of interest with your office being involved. So I would suggest to you that you need to send this to an outside entity for all purposes.
We absolutely will take that under advisement, legislator, and will do.
Yes, legislator, we will speak with legal counsel about that and take that back.
Legislator Rhodes.
I'm just trying to wrap my head around this. Has anyone sought an ethical opinion with respect to whether a claim by a sitting legislator can even be maintained? Because I think, just thinking about it, I don't know how this does not create massive conflicts of interest on both sides of this equation.
Respectfully, Legislator Rhodes, I would just ask, to the extent, this is a filed notice of claim, so it's a notice of pending litigation.
Right.
Summons and complaint has not yet been filed. However, we're happy to discuss this further in executive session or with legislative counsel, rather than comment on anything of an, attorney-client communication.
Okay.
Or anything of an ethical concern.
Let me ask you this. Has the 50H been held? Has the municipal hearing been held?
I don't believe, no, it is not, actually. It is not. There has been no activity on this other than the filing of the notice of claim.
Okay, I mean, I'm disturbed of the procedure here, but I don't want the county to have waived its ability to have a municipal hearing. In other words, I mean, there's been discussion, maybe tabling tabling the motion, tabling the contracts, but to do that, I just don't want the county to be left without an opportunity to conduct that municipal hearing.
Yes. So for the record, legislator, the county did not waive the 50H hearing. Actually, the claimant waived the 50H hearing.
Well, it's not a, but maybe we should go,
Yeah, I think perhaps this might be best addressed in executive session.
Right, at this point, I'll take a motion to table. Moved by Legislator Ford, seconded by Legislator Rhodes. All in favor of tabling signify by saying aye. Aye. Those opposed? The item is tabled. You can go to the next one, which is E110.
Legislators, this is a contract with Louis Joes for the lawsuit of Scannell against Nassau County and et al. This was let pursuant to the normal procurement process. If you have any questions, happy to answer the same.
Okay, I have no questions, just an observation, another one that's several months late in terms of coming to us, but any other questions? Nope. Why don't we move on to the next one, which is a contract with Vincent McNamara?
This is a contract, the law firm of Vincent McNamara, E11121, for the case of Esther Yoon against Nassau County. This was procured, I'm going to call it under an emergency. In other words, it was not bid. There was an immediate trial need. The law firm was identified as being qualified in this area, and it was assigned that way as a sole source. It is coming to the legislature with rapid speed.
Was this handled in-house or by another attorney? Before?
It was being handled in-house.
Okay, then at the trial stage, it was determined to bring on trial attorney? It says the trial is set to commence on June 22nd.
It was. So legislator, what happened was just due to, we had an experienced litigator who was handling this matter and was scheduled for the trial, but he recently resigned. And in light of the caseloads and the upcoming trial date, we thought it would be best to assign to outside counsel to handle for the trial.
I think that was a good choice. So. Anyone else have any questions on this? Nope. We have, next one is with Bond Schenik.
This is a contract with Bond, Schenck, and King to handle the personnel matter of Hano v. Nassau County, which was actually at the New York State Division of Human Rights.
Any questions on this contract?
This is 11221.
Yes,
I apologize.
112.
All right. So this is also a contract that's long overdue, that's late in coming to us?
I don't know if I would agree with long overdue, but I guess we can agree it's late. I wouldn't want to be a wise guy.
Okay, and there's like, with this particular individual, I guess there's like two separate issues. This is something based on his human rights complaint, the Human Rights Commission complaint?
This particular matter is relative to the state DHR complaint, yes.
Okay, because then there is another, there's another issue with this person that would be treated separately? in regards to
I
whistleblower?
just wouldn't speculate as to that on the record at this time. I would just say this matter is related to this, and if there's something else,
Just
we'll address that at that time.
particular issue, right? The
Yes.
one- Okay. All right, thank you.
Any other questions on this contract? 112. Okay, next one is 113 with Leahy and Johnson.
Yes, this is a contract, pardon me, just pulling my notes up. 11321 is a contract with Leahy and Johnson for 4 cases. It is a case-specific contract for these 4 cases: Coda, Cassiano, Gleason, and Iacone. This firm was previously engaged by the county in handling this matter, so this is partially an amendment to or a continuation of prior work that they were doing relative to procurement. If you have any questions, happy to answer the same.
My only point is, I think we requested this in the past, but going forward, we want the contracts with the attorneys broken out per case, so that we don't get a contract for 4 separate cases. We want them presented individually. There's a number of reasons for that, one of which may be, someone up here might have a conflict with one of the cases and not the others, but there's other reasons. I think it's cleaner to do each one individually.
Legislator, just to clarify what you mean, because we've had some internal discussions about that, and we're very much interested in doing precisely what this body would like. Are you saying you would like every single case on each, for every firm, an individual contract, no contract shall have more than 1 case, which is totally fine. I just wanted to make sure I understood your directive.
Isn't that how it's been done?
Well, in the past, so this is the distinction, and this is exactly why I'm asking.
Okay.
In the past, we've had what we call qualified areas contracts, which the legislator has made very clear are unacceptable. We cannot have contracts that are just sort of open-ended. So what we had transitioned in this regard is to contracts that specifically enumerate and delineate which cases shall be covered under those contracts. But what you seem to be saying is, no, Mr. Lippert, what we'd really like is a specific contract for each individual case. And we absolutely can do that, but I just wanted to make sure I understood that's what you wanted.
Why don't we have some discussions with this going forward? We don't want to create anything that's cumbersome for the department, for the county attorney's office, but at the same time, we make sure it's being done as efficiently and as effectively as possible.
We're happy to work with council to do it in a way that works for the legislator, as always.
Any other questions? All right, last one for the county attorney's office is Montfort Healy, number 114, E114.
This is a contract with Montfort Healy for the case called Skelos. This was a car accident case in which the county was a co-defendant. The case was resolved all between other parties. The county paid nothing, and the case is now over.
Okay. Any questions on this one? Nope. All right. Thank you, Brian.
Thank you. Have a great day.
Okay. E106, Parks Department.
Good afternoon, Presiding Officer, Legislators. Dennis McDermott, Deputy County Attorney. This is a request for an approval of an amendment to a license agreement for the operation of the food and beverage concession at the Carlton in the Park. The amendment is in the nature of a temporary workout that accomplishes several things. It provides certain COVID-related economic relief to a county concessionaire who's providing food and beverage services for county residents for nearly 30 years, and due to the restrictions during the pandemic, saw their gross sales drop a staggering 70+% in 1 year. It also extends the term of the current license by 9 months to afford parks adequate time to process the new RFP that was issued on June 18th, 2021, which is replacing the August of 2019 RFP, which was interrupted, and then when the proposers were unable to maintain their offers, effectively withdrawing the RFP process, parks had to cancel that RFP. It also provides for the continuity of services at Eisenhower Park, and it avoids the possible costly litigation respecting issues of force majeure, frustration of purpose, and impossibility of performance. Under this workout, the Carlton will use the Paycheck Protection Funds to pay restructured and reduced minimum monthly payments for the COVID period from March through December 2020, as well as paying the utility charges. Starting January 1, 2021, the workout gives additional relief by suspending and waiving the required minimum monthly payments, and the Carlton will pay the gross percentage fees that are required in the original agreement only. The original agreement's minimum required payments will be reinstated once 6 months have elapsed after all government restrictions on occupancy are lifted respecting Nassau County restaurants and catering facilities. Additionally, the food and beverage concessions for the golf courses at Eisenhower are being included, as they are also being included in the new RFP, since the location of the facility being adjacent to the golf courses and the golf administration, it would seem to be a natural inclusion. If you have any questions, I'd be...
Okay, any questions from the legislators? Legislator DeReggie Witt.
I thank you for including all the payments that they received. So are you, did they basically give you enough information to show that they use the PPP money in the correct way?
Yes, they did, legislator. They submitted a document where they received approximately, I believe it was $580,000, and while payment of the license fees is authorized under PPP, it's not required. They could have actually used the money for other authorized PPP uses, but they instead want to make this payment, or actually have made the payment.
Okay, so did they deplete all of those funds?
They used all of the funds mostly for, as the program is called, paycheck protection.
Right. Okay. All right. Thank you.
Okay. Any other questions? All right, thank you.
Thank you. Have a good day.
You too. Next contract is with Corrections, E107.
Good afternoon. Michael Golio, Captain with the Sheriff's Department. This is a new contract for the provision of medical, mental health, dental, and ancillary services to inmates in the custody of the Nassau County Sheriff's Department or incarcerated at the Nassau County Correctional Center. The solicitation was by RFP, issued in November of last year. The maximum amount of the contract over the 5-year term is $122 million. It's a term of 5 years with two potential 2-year extensions at the end. The first year encumbrance is $16,708,550.
Is there anything different than what the services that will be provided going forward as opposed to what the hospital's been providing to the inmates currently?
There are some changes in services that are going to be provided. There's also some significant changes to the provisions of the contract. Yes, both.
Do you want to comment on those at all?
Sure. So with respect to the contract itself, there's now a identified staffing plan with identified positions and titles that can be monitored by the contract monitor, and it's tied to the in-house inmate population. The population is determined once a year for the prior 12-month period and then carried over for the subsequent 12-month period. There's also a clear budget with identified line item categories and amounts also based on population. The vendor is not permitted to reallocate any budgetary line items more than 10% without the approval of the department. There's now a clause for indemnification and defense by the healthcare corporation. There are now performance indicators with financial penalties, and some of those highlights are there's going to be an electronic medical record within 9 months of the execution of the contract. NCCHC, that's the National Commission on Correctional Healthcare Standards, certification within 18 months. There's an outpatient referral review for every time that they send people to the clinics at the hospital. That's going to be reviewed. And an inpatient utilization review. Those are for people that get admitted to the hospital. There's a telemedicine requirement. We're encouraging them to utilize telemedicine wherever possible. And then there's a reconciliation once per year, no later than March 31st for the billings.
Okay. Well, thank you very much. Appreciate that. Any discussion, comments? Thank you.
Okay.
Contract E115s with the National Development Council. Yes. Oh, okay, Mr. Golio. We did have a question for you.
I'm sorry?
Hi, I'm sorry,
Hi.
I had a question for you, Captain. So in terms of the discharge plan for the medical services, I know that council did speak with you and to address some of the questions I had. So in one of your responses, it was regarding to like medication for, you know, some of the chronic diseases like high blood pressure and diabetes. I understand that you give the prescription to the individuals as opposed to giving them the meds?
That's correct. The requirement under the contract is psychotropic medications, HIV medications are provided as medications. All other medications are provided by prescription.
And so we're certain that those individuals being discharged would have some level of health care coverage to allow them to access the pharmacies, and that the pharmacies that would accept that coverage are accessible, easily accessible?
So that's part of the concern. Obviously, we're focusing more on Medicaid enrollment during the period of incarceration so that when people do get released, that they can have access to care that they need. There's also community referrals, whether it's a community provider or a general community resource as a referral. But we did discuss some of the things that you spoke about earlier about wraparound services and a reentry program that would include making certain that the people have the resources available to get the medications upon discharge. But that's outside of this contract. That would be another program.
So which means that people will be discharged from the jail potentially without having those services, therefore not being able to access those meds?
Well, they're getting a referral to a community provider and they're getting a prescription. That's the hospital's obligation under this contract.
And the community provider will accept that prescription without any coverage and make sure that they get the meds. Is that what you're saying?
That's my understanding of the way the hospital is making the community referrals, either to a clinic in the community or someone that they work with through the hospital.
So like one of the FQHCs, in other words?
Correct.
Okay. So we know those entities aren't open on the weekends. Are we discharging people on Friday and they don't have any meds over the weekends? Like, what are we doing here?
So as a general matter, individuals who are released for terms of incarceration are released Monday through Friday. You could have some bail releases on the weekends, but generally the discharges are Monday through Friday.
And so those released on Friday potentially could go the whole weekend without having any meds?
I do understand the concern, and as I discussed with counsel, this contract is confined to what the hospital's obligations are under the contract, but there's a broader discussion that has to be had regarding the wraparound services.
You addressed a lot of my other concerns, and it's just this one, your response still leaves me with more questions. So I do have a concern about us not giving them at least the meds to get them at least 2 or 3 days until they can get an appointment. Because even if they get discharged on a Thursday, there's nothing that says for certain that our community partners or the community entity is going to be able to see them that Friday. It could be days maybe before there's some level of, an appointment made and able to see a doctor. Is there any priority given to those individuals, to get appointments or anything like that?
I would have to speak to the medical people. I will do that and get back to you. I do
would
know
really
that they're
appreciate
doing the referrals in the community. I don't know the mechanics of all the referrals.
Oh, yeah, I'm going to need some more information. I really appreciate that. Thank you.
Okay, any other questions? Legislator DeReggie Whitten.
Are you able to enroll someone in Medicare or Medicaid
Medicaid.
while they're in the jail?
You can do all the enrollment. The coverage doesn't start until they're discharged unless they're hospitalized. So there is Medicaid coverage for somebody who's an inpatient in a hospital more than 24 hours. The county can get funds through Medicaid for that. All other medical services get activated upon discharge.
And what percentage of the inmates would you say leave with that insurance in place?
I don't have that number. I couldn't tell you. I do know that it's a focus. It's something that we've identified as a priority, and in this contract now we're getting the hospital to cooperate by doing the Medicaid enrollments.
Yeah, that would be good to know it'd be good to get as close to 100% that are eligible as possible.
Absolutely.
I know it's a lengthy process. I know it's not an easy process. So that would be good information to have if you can obtain that.
Okay.
I'm sorry, we're never going to let you go. Thank you very much, Captain. You had mentioned, about telemedicine. I guess, is that like the teledoc type of thing where, I guess, is this so that the inmates can then use their computer and speak with a doctor? Or am I misunderstanding it?
So it would be telemedicine services, basically video conferencing between the inmate and a practitioner, whatever level that would be. But that would be at the direction of the medical people. So it wouldn't be just a sign up by the inmates. That would be for a service that couldn't be provided at the facility, and in lieu of transporting the inmate outside the facility, we would do the telemedicine hookup.
Prior then, and then they may be transported based on that discussion.
Could be later on,
telemedicine.
yes.
Okay.
Yes.
So then, when somebody is then released from the correctional facility, and I guess like thinking about their prescriptions and so forth, is that a service that would still be offered to them to have some sort of communication with telemedicine, where they can, if they have a follow-up question, to still be able to utilize telemedicine? Or
Certainly, depending on who the provider was and whether or not they were going to continue the patient relationship, certainly it's a possibility.
Okay, thank you.
Any other questions? No? Thank you, Captain Golio.
Thank you.
Last one, E-115, the National Development Council.
Good afternoon, legislators. Kevin Crane, Office of Community Development. Item E-11521 is an amendment to a community development contract with the National Development Council. The intent is to extend the term of the contract and also add a new program, the Main Street Recovery Grant Program, which will open the current Restaurant Recovery Grant Program to all small businesses in the county that have suffered through economic impact of COVID-19 pandemic. The amendment will add approximately $710,000 in additional community development block grant COVID funding, as well as $10 million in funding from the American Recovery Program. So I would entertain any questions you may have.
Okay, so I see that this contract originally was started in April of 19 and expires, it looks like, if without this extension here, it would expire in 22 of March, the end of March 22. Would that be correct?
Yes, NDC was procured through an RFP through our office. Generally, we have a 3-year contract with them. That was the original
So the
contract.
dates that I've just said are correct. It would expire in March 31st of 22.
I believe that's right, yes.
So you know what my next question is, don't you? Why in the world are we extending a contract instead of going out to bid when we've got lots of time? We're taking a contract and going from $3 million and change to $13 million and change. How is this not a new thing? How are we not going out to bid? I can't for the life of me understand why.
No, I understand your concern, and that was discussed at length. We had guidance from the county attorney's office as well as the Office of Compliance and with the county's consultant on the American Recovery Plan, the Hagerty Consulting, to review the procurement that we had done at the outset, as well as adding additional funding for this program.
Yeah, well, with all due respect, that doesn't begin to respond to the question.
As to why we didn't issue another procurement?
Yeah.
It was the
You've got
guidance
lots
that
of time for it. You've got until the end of March, until the end of next March.
But an additional procurement, as you know, takes several months to.
Right, and you've got more than several months.
But just to start the program is what I'm referring to. What we're trying to do here is to bring the American Recovery Program as well as the COVID money out to the businesses that are in need of it at this time.
I'm sorry, but how does that answer the question? They've still got, you can put out money, you can put out as much money as you need between now and the beginning of the beginning of April.
Well, there's very little money left on this contract.
Right.
The additional money that's being added to the contract is to establish the Main Street program. Right now, the Restaurant Recovery Grant Program is essentially ended. But there's money left on that contract. But The rules that are in the contract would not allow us to
So
make
why
those
not
funds available to
extend, why
small
not put
businesses.
out a little bit more money now? And why do we need to extend the contract by 3 years?
Well, that's what the American Recovery Program allows. So the intent was to provide the funding, put the money in the contract, and allow it to run its course so that we would be able to receive applications, or NDC would be able to receive applications and make those awards.
How much of the 10 million would actually get to the businesses?
9 million. It's a 10% fee that NDC would utilize, so $9 million would go out in grants to the businesses.
And
It's up to a 10% fee, so that's the maximum that fee they could charge.
yes, then if this contract is not in place, then the program is not in place, and the money's not getting to the businesses. Is that
Correct. Right now, there's about $400,000 left in the restaurant recovery program, but those funds will go only to restaurants. And we believe that the restaurant component has exhausted the applicant pool at this point. So we wanted to open up the funding to additional businesses.
how, if you had to go for another RFP, how long would it take to get that process?
Generally, an RFP process from the initiation to the selection is at least 6 months.
Okay.
And then the contract phase as well.
Any other questions?
I'm advised that the standard timeframe to do an RFP and route a contract is about 10 months. So
Understood. So, two things. First of all, what do you mean by a fee of up to 10%? That could be 1, or it could be 9, or 10, or what does it mean?
well, 10% is the maximum allowable. So if NDC were to push the funding out faster, if we get more applications in, the fee could conceivably be reduced. But
So their fee is dependent on their performance?
Yes.
It's a
Yes.
mechanical calculation?
exactly.
Okay, I got it. So, once again, I just want to, I don't want to delay funding to various deserving businesses, and I get that you want to push that out as quickly as possible, but I don't get why we're extending it 3 years. That part I don't get. So, what I'd like to know is there any reason that you can't bifurcate this issue? In other words, any money that you want to push out between now and the end of March, come back to us and say we'd like to do that 3 weeks from now. It's, I'm not talking about years or months. And the other part, in terms of extending the contract, as I say, I really haven't heard any particularly interesting explanations for that.
So just so I understand what you're asking is, the contract would be tabled and be brought back to you in the next session?
In 3
with
weeks.
a shorter term?
In 3 weeks, we would, 3 weeks we would, I guess we could do it. Yeah, we could do it in 3 weeks. But, in other words, come back with a split. Here's the money we want to push out now immediately. I'm all for it. And then we, and then come back with either a statement that you're going to go out in an RFP for the next 3 years after that, or give us a really good, satisfactory explanation why you can't or shouldn't.
Well, is the request that we decrease the amount of the additional funding?
I don't know what the amount of funding should be and ought to be. As I say, we're dealing with I'm dealing with two separate issues. Issue number one, get the money out as quickly as possible between now and March 31st, the maximum amount that you're able to get out. That's issue number one. Issue number two, in my mind, is extending the contract 3 years starting in April of 22. That's the second thing. And I would like to see a split in that, or alternatively, a really good explanation why it ought not to be split.
Okay. Well, it's certainly not our intention to take 3 years to spend this funding. As you mentioned, we want to get this money out to the businesses who've been
So then
earning.
you're kind of saying that I'm right, I think.
Yes.
Okay, good.
Well, as far as the need for the extension, the amount of the term of the 3-year extension was, I think, just to coincide with the ARP ruling as to how long we have to spend the funds. But we intend to get the funding out as quickly as possible. But the 3 years was to comply with the ARP allowance and to also give us some flexibility so that the funding could be used. The restaurant recovery money went out very quickly, as you all know.
Now I'm getting a bit of a different picture. You think that you might have some of this money left over, this specific bucket? I'll use the administration's favorite word for money.
No, I think the ARP funding is more flexible than the community development block grant funding is. We've also increased the block grant funding that went out with the restaurant recovery. It was either a $5,000 or a $10,000 grant, depending on the size of the business.
All right. So
With
then,
the
what
ARP
I'm
funding,
asking. So then, I think we're in agreement. You can come back and give us a better feel for what you can get out more quickly and what you can't, and why you ought to keep this vendor or get a different vendor if there's anything left over.
Well, our hope is that the full $10 million will go out very quickly, that there will not
That'd
be
be
a
great.
reason to
That'd be
reduce
great.
it.
Then you won't need an extension.
That's possible, yes.
Okay.
And on that note, I would like to let you know that the Boost Nassau Center, which is the Nassau Center, which was established at Eisenhower Park last month, I believe, is hosting a webinar this coming Thursday. We do have a flyer that I can provide to all of you, and we hope that you will help promote that webinar to attract small businesses, to let them know what resources are available, not just the Small Business Recovery Grant, the Main Street Recovery Program, but also the rental assistance.
Yeah,
that's
that'd be
available,
great. I
and other
think
state
we'd
funding
all love to
sources
have
as well.
that. I think we'd all love to have that if you can
So
get
we
that
can
to
spread the
us.
word and get as many businesses participate. I think the money will flow very quickly.
Yeah, if you can get that to us real quickly, that'd be great.
All right, I have that
So
here, and
I'm
I
going to
can
move
email
to-
to everyone when I get back to
I
you.
think we have it. It was sent, I think, this morning from the Minority
Excellent.
Affairs
Good.
Office.
Okay.
I just have another follow-up question. If we don't vote on this today and wait for 3 weeks, is there a delay in getting these monies into the restaurants?
There will be a delay because NDC would not be able to, and issue any grants until the funding is approved.
All right, I mean, Deputy Presiding Officer Capel has been trying to have the administration address this ongoing issue with these contracts that are ballooning in terms of length and amount. However, and we're looking for ways to change the administration's conduct in that regard, but we do not want to delay getting needed resources to restaurants who have struggled so much during the pandemic. So I think it's our intention to move this forward today.
I appreciate that. But just to clarify, this is not just a restaurant program. This would open it up to all small businesses at 50 employees or fewer, 50 FTEs, full-time equivalents, and $5 million in total revenue. But it's to expand the restaurant recovery program to address those businesses that were left out at the outset.
All right, good. All right, okay. Any other questions? All right, thank you, Kevin.
Thank you.
So we have all these contracts before us. I'm going to read them because there were several that were tabled so that we make sure that we know what we're passing and what was held. So the ones that we're passing now will be A30, A38, A39, A40, A41, A42, E108, B19, B25, B26, E100, E102, E103, E104, E105, E110, E111, E112, E113, E114, E106, E107, and E115. Any further debate or discussion on those items? Any public comment? All in favor signify by saying aye. Aye. Those opposed? They all pass unanimously, and now I'm going to put the rules in recess, and we'll move on to the other committees.
Okay. Thank you, everyone. At this time, I'm going to call the Public Safety Committee to order. Okay. I will ask the clerk to call the roll.
Thank you, Madam. Public Safety Committee roll call. Substituting for Legislator Debbie Muley, Joshua Lafazan. Thank you. Legislator Sheila Bino. Ranking Member Delia DeRigi-Witten. Legislator John Ferretti. Substituting for Vincent Muscarella, Legislator William Gaylor.
Present.
Thank you. Vice Chairman Stephen Rhodes. Chairwoman Denise Ford. We have a quorum, ma'am.
Sorry. Thank you very much, sir. There are 8 items on the agenda today, which are clerk item numbers 187-21, 188-21, 226-21, 238-21 through 239-21, 240-21, 241-21, and 242-21. Clerk item number 18721 is a local law to amend the Nassau County Administrative Code in relation to amending the Nassau County Human Rights Law to preclude discrimination against first responders. May I have a motion? Moved by Legislator DeRigi-Witten, seconded by Legislator Ferretti. The item is before us. Okay. Legislator Lafazan.
Thank you, Madam Chair. This bill amends Nassau County's human rights law to include law enforcement officers as a protected class, and I apologize for my difficulty speaking. I am recovering from surgery, so I hope everyone can hear me. The recent widespread pattern of physical attacks and intimidation directed at the police has undermined the rule of law and put all our civil liberties in danger. As legislators, we have determined that there is an urgent need to enhance the legal protections afforded to our law enforcement personnel and other first responders under the human rights law in order to encourage them in their crucial service to the community, to make them whole in the face of injury suffered at the hands of rioters and other individuals bent on lawless behavior, and to deter and punish such destructive behavior in order to protect the human rights of all people. Therefore, this law sets in stone that it shall be an unlawful discriminatory practice to harass, menace, assault, or injure an individual due to such individual's status as a first responder, and that those who violate this provision will be subject to a substantial civil penalty as well as a civil liability to the first responder. I hope we pass this bill, and I thank my colleagues for their support. Thank you.
Thank you, and I hope you feel better. Recover. Okay?
Thank you.
All right. Anyone else? Legislative Rhodes?
I certainly could not agree more with my colleague, Legislator Lafazan, than I do. I think this is legislation that's long overdue, and you know, I believe I speak for the members of our caucus when I say that we intend to support it. So thank you.
Legislator Bino.
Thank you, Legislator Ford, or Chairwoman Ford. I have some questions regarding this bill. In particular, I'd like to understand the intent of this bill.
Sure. You know, quite frankly, I won't be as articulate as I was in my prepared remarks, but the intent of this bill is that it was absolutely outrageous to witness officers protecting us in the line of duty be assaulted, menaced, and harassed across the nation. Quite frankly, it's outrageous. Our officers protect the human rights of all people, and the intent of this bill is to protect them so they can protect us.
Is it to protect them against being menaced and harassed or injured as well as being assaulted? Because the assault makes absolute sense to me. We can't have police officers assaulted in the line of duty.
Yes, the intent is to cover all of the above to protect our officers.
From being harassed. So can you tell me what harassment looks like and menacing? Can you give me the definitions of those things?
We have the definition in the penal code, which I do not have on me, but I'm happy to have counsel provide it.
You have it in the penal code, you said?
Yes, and I believe my counsel is shaking his head yes, that the definitions we reference were referenced in the penal code and that those definitions are available. I don't have them on me on my laptop, but I can provide them for you.
Okay, so harassment you know, in a lay person's term, in my understanding of harassment, is that harassment can be when someone considers that they're being intimidated or that they're subjected to some level of anxiety. Does that fit into your penal code definition?
Give me 1 second. The definitions were laid out in the penal code, and we would file those definitions as laid out in the penal code.
Yeah, in order for me to be able to vote on something, I need to understand exactly what you're referring to in terms of the definition of harassment. I just need it for clarity. And menacing. I can wrap my mind around the physical attacks. That makes all good sense to me. I just need a better understanding of.
Legislator Bino, you know, we had a long caucus on this bill, and I understand you have some issues with this bill and the language we use. With any bill that I consider, I'm open to amendments so long as they meet my intent and so long as I believe that me voting on that bill will be in the best interest of my constituents, and in this case, protect our law enforcement officers. So I'm happy to consider any amendment you have, and I'm happy to meet with you on this issue. I'm happy to meet with law enforcement, and I'm happy to meet with the unions, but I plan to vote yes on this bill.
So the intent, but the intent on this is you stated now on the record, you stated that the intent was to deal with harassment, menacing, injury, and physical attacks?
The intent is to follow the definitions in the penal code in which we wrote this bill.
Okay. And so it's my understanding that this also, does this put police officers in a protected class?
First responders are already protected under the human rights law. This specifically gives them a human rights course of action.
And does that mean that officers now can file civil suits currently before this bill being passed?
Not under the human rights law.
Okay. And so if I were to give you a scenario where a young person was, I just want to make sure I have your attention. Good. So if I were to actually provide you with a scenario, well, I'm going to wait. Okay. So the scenario is someone is, in a case like the gentleman who was running down the street, I believe in Massapequa, covered in feces, and he got engaged with the police and he injured the police officer. Would he be, in this particular case, would this particular case be covered under this bill, and would that officer be able to then file a civil suit against that individual?
I don't know enough about the circumstances of what you're referencing. I got the Newsday article when it was sent to me an hour ago.
Would it be a difference, because this covers injury? Does this bill differentiate between an officer being injured in the course of the process, or just that he gets injured?
Again, I do not know the specifics of the case. It would have to be the intent of the individual to assault, menace, harass, or injure the law enforcement officer. But again, I will not speculate on this specific case because I do not know the details.
If somebody was protesting and there was a wall, if there was law enforcement and they were approaching law enforcement and they were saying no justice, no peace, and they were moving forward toward law enforcement, and there was some interaction with that individual, and an officer gets injured. In that particular case, is that a physical attack against an officer, or are you classifying that as something where there should be a civil suit against that individual?
Sure. So we spoke about this in caucus at length, and I'll say one more time. In each individual hypothetical, it would have to be the intent of the individual, going back to the intent of the bill, which is, again, the intent of the bill is to protect officers from assault, menacing, harassment, or injury. I'm not going to entertain hypotheticals. We spoke about this in the caucus room, but that would be the intent.
So we speak about a lot of things in the caucus room, and it's been the exercise that when we speak about those things in caucus, we come out and we get them on record. Because we all are representing our constituencies, and we want to make sure that we've asked the questions, right? In particular, my concern about this bill is that, and because first and foremost, let me tell you what's not of concern to me about this bill, because I wholeheartedly support it, is that individuals that come here to Nassau County or live here in Nassau County should not assault our police officers ever. Ever. That's not of question. What I am concerned about is the use of the language harass, menace, and injure. And so is it your understanding that a civil suit that might be brought against someone for the purpose of harassment, menacing, and injury, would that individual have any opportunity to have legal counsel in the event that they could not afford one? So in the case that under a criminal act, they get legal aid. In a civil case, would for instance, a millennial who was protesting, or someone who stole something from the local 7-Eleven, they run out, and the police officer, they get entangled and there's an injury, would that person have the ability to have any type of legal counsel represent them?
Sure, Legislator Bino, again, I understand your concerns, and it's why I expressed to you, and I expressed in public, that I'm willing to look at amended language of not just my bill, but of any bill. I also understand your need to get these concerns on the floor.
Okay, may I interrupt? I'm sorry.
Oh, sure,
Okay.
thank you, Madam Chair.
I'm actually going to close.
I just want to say basically something in support of you, Legislator Bino.
Say again?
Okay? I just want to make a statement, because I think that we have to bring this all back to all of us that are sitting here on this dais. And I appreciate your comments, Legislator Lafazan, that this is your bill for your constituents, but obviously we're all considering it for all of the residents in Nassau County, and especially those of all of law enforcement and first responders throughout all of Nassau County. But I think that Legislator Bino does bring up, some interesting issues in regard to this legislation. Because I think that, and I do, I think that this is worthy legislation. It's very different than the tone that is being set by your fellow legislators up in New York State, as you appear to go a little bit pro-police, where the feelings from New York State regarding law and order and law enforcement is in contrary to what this legislation is intending. But that being said, it is important, when I think about what happened last year in New York City, visions of that one police officer who was lying unconscious in the street, all alone and whatever. But it can go both ways. But I think that we also have to protect the public as well. And when you talk about, physical, anything that can happen physically to a police officer or anybody who is a first responder, definitely. But sometimes what happens is, and I know with harassment and people shout things at cops and whatever, and sometimes people may not really realize that they're saying something derogatory to a police officer, and I think most officers have learned to be able to handle something like that, and it's not easy for them. I'm sure that there were times when they just would like to shout back. But I would not like to see somebody all of a sudden, finding themselves on the wrong side of the law because of comments they made to anybody as a first responder, and especially our police officers. So I think that this is something that we need to take a look at. And I think that we can pass part of this, but I think that it needs that we probably should then have a general discussion as to perhaps there should be amendments made to this, and I don't know, even on our side, I think we have to take a look at this. We can't just say, because, when we talk about, verbally abusing is one thing, but if, you might have somebody who just is having a bad day, or maybe somebody who's mentally ill, may see an officer and may shout something out at them. I don't want anything to happen to that, and then that person needs to hire a lawyer, and whatever happens. We're trying, I think, the whole point, and I have to say, under the leadership of Commissioner Ryder, he has made it a point with his community policing, with his community civilian board, and everybody, to make it so that we're one big community, whether or not you're in law enforcement or you're outside law enforcement. And I think that we really need to keep that dialogue going, and we need to get that goodwill going so that everybody feels that they're very comfortable in approaching our police officers, in dealing with them and speaking with them. And I don't think, I firmly believe, and I don't know how my side feels, but, my son is fifth generation police, so I've been around police officers all my life, and I respect the job that they do. But I also know sometimes that things can happen, and I just really take a look at a lot of the people in my communities that may just have had a bad day, and I just don't want them to get into trouble because maybe they sassed an officer, So I think, Legislator Bino, I know that you had a discussion within your caucus, but I really think that this is a discussion that may be worthy of having it out here on the dais for all of us to have.
And I agree, and that's just why I still wanted to raise my questions. Thank you, Chairwoman. That's
But
fine.
if you have, you can continue.
I just want to close. Yes, okay. I appreciate it. I just want to close by saying, again, I don't want to see our officers attacked, physically attacked. That should never happen. Shouldn't happen anywhere in this country, specifically here in Nassau. And any additional protections we can give them based on an all-out assault, I think we should consider those things. My concern is that if someone were to assault or injure an officer because they were resisting and that kind of thing, there's a criminal aspect of that, and there's a higher burden, a threshold for burden of evidence. But when we start talking civilly and we start talking about harassment and menacing with the lower threshold requirement, I'm afraid that we might burden our citizens unnecessarily so with a civil process where they have no remedy or any assistance or recourse to have legal counsel. And so that is my concern, and it's a concern that I think has to be addressed before this bill can be passed in its current form.
And I agree, because I think we also need, I'd like to maybe reach out to the police department to find out, what are the situations that officers are finding themselves in? People, we should all be civil, regardless of who you are. Officer talking to a civilian, civilian talking to an officer. I agree with that. But I really think that there's a fine line there, and I just, like you, I just don't want to burden somebody all of a sudden they're in trouble, because maybe they said something wrong. And I don't know whether or not it can go that far. Is that something that an officer can then say, they spoke disrespectfully to me or whatever, and then that person is in trouble?
That's
we're
right.
trying to avoid situations like this.
And we don't want to see things like what happened on January 6th or, other issues that may have played out across the country where officers were assaulted. But in the moment, I believe that we're charged to do so much in so many different ways that we can't move this forward, to me, without having addressed this. So if this is good, I actually think we should move to table this item so that we can work on it.
Legislator Ferretti.
Thank you, Chairwoman. Look, first let me start by thanking Legislator Lafazan for drafting this bill. I think today, in today's world, we're often more concerned with defending those who are doing the wrong thing than protecting the people who are protecting us. And I think that this bill goes to that. I agree with Legislator Bino that we certainly don't want any of our men or women in blue assaulted, but I also don't think we want them menaced. I don't think we want them harassed, et cetera. Everything in this bill that's written in there, we don't want our officers under that, that happening to them either. I support this bill as written today. I believe that the process, and that's with all due respect to Legislator Bino and Chairwoman Ford, the process, you know, it can still be amended after it goes through committees if needed. From my reading, I don't think it needs to be, but of course, I'm always open to listening to suggestions. But the reality is that the behavior that's being protected in this bill is I don't think our officers should be subjected to any of it, whether it be assault, harassment, menacing. It's all unacceptable, and we need to protect our officers, and that's what this is doing. So, you know, I hope that this not only passes today, but that this sends a strong message to Albany, specifically to the representatives in Albany who represent Nassau County residents who have been less than supportive to the men and women in blue, that we don't stand for that we're united, hopefully we're united, in putting the rights of our men and women in blue before the rights, or, you know, or at least at the forefront, and we're concerned with their safety, with their rights, not just the safety and rights of those who do the wrong thing. So I do not think this should be tabled. I think it should be moved forward today as is, and if amendments are made, they're made after it's moved forward today. Thank you.
Legislator Gaylor.
Thank you, Madam Chairwoman. So first of all, I'd also like to commend Legislator Lafazan for bringing the bill to the table. And I plan to support it as it's written. What I find interesting is that these definitions of harassment, menacing, intent, assault, they're all codified by state law. It's called the Penal Code. The definitions are clearly laid out. Harassment is defined when somebody acts with intent. Intentionally means, you know, with an objective means and purpose to cause harm to somebody. And that's what we're really talking about, committing acts which place someone in fear of physical injury. Menacing, when someone intentionally places or attempts to place another person in fear of death, imminent serious physical injury, or physical injury. That's the definition that the state has given, state law, for menacing. Assault, if with intent to cause serious physical injury to someone and actually causes serious physical harm to that person or another person. So the definitions are already laid out by state law. It's nothing for us to interpret here. What ends up happening if a police officer believes that now he has a civil action, he seeks the advice maybe of counsel, and if counsel and that police officer believe that based on that fact-specific scenario we're trying to pin Legislator Josh Lafazan down to it at this stage, which you can't do. But if that officer thinks that based on the facts and the situation that has occurred to him, that the elements of each of these crimes has been committed and satisfied, then we give him a right to bring an action. And so it's part of due process. And so I don't see any real issues with the way the bill is written today, or really much discussion to be had even after today. I think it's a good bill. It goes to support our police officers who deserve that. I fully plan to support this bill as it's written, Madam Chairwoman.
Thank you very much, Legislator Gaylor, and I intend to support it as well, but I also think that there should be further discussion, you know, even before, you know, so to see whether or not, and I understand harass, menace, and assault, but we also have to then take a look at, you know, I think Legislator Bino brings up some concerns about some of the population that we do have here in Nassau County, that some people that may not be fully aware of, like, their reactions or the way that if they speak or they yell at police officers and stuff like that, to find themselves on the wrong side of the law. They may not be aware
Yeah,
that they're
but-
breaking a law.
But I don't
So-
see anything, Madam Chairwoman, in the bill that singles out a particular class of people or
No, I'm not saying
anything.
the class of people. What I'm saying is, like, sometimes what we're saying is that we're setting it up that, like, to harass or, maybe a group of kids may be yelling at an officer or something like that. Does that constitute harassment where that they could get into trouble? I mean,
Well, again, it's, under the facts of that situation have to be determined, and, you have to meet the elements of the defined crimes as the penal law lays out. So
Okay.
it's hard.
Legislator Rhodes.
What I was going to sort of dovetail off Legislator Gaylor's comments, each of these crimes lays out that you have to establish as an element of each of these crimes intent. So in the situation where you're talking about kids, did they completely understand what the consequences of their actions were? That's obviously something that has to be considered potentially by a civil jury if we're talking about civil litigation. It's always been the case that there are different burdens. Obviously, the criminal burden is to prove beyond a reasonable doubt. Obviously, civil liability carries a lesser burden, that it's more likely than not that the elements are met. But that's something that's a standard on every crime. I mean, take a look at probably the most famous example is the O.J. Simpson case, where there was no criminal liability, but there was civil liability to be found afterwards because there's a different burden of proof. You may not have been able to establish that it was more likely than not, but you were able to establish that there was a preponderance of the evidence that there was. So, this distinction is not unique. Legislator Lafazan is not trying to create something new. We're just simply seeking to apply situations and laws that already exist to the particular circumstances to not only protect police officers, but firefighters, EMTs, or ambulance personnel, all of our first responders. I think it's a worthy cause. I don't have a problem with the language that's in it. I mean, we can certainly have additional discussions, and I would encourage our fellow legislators to have those discussions, before we, and there'll be a public hearing on it. It's a law, so we will have a hearing before there's a vote on it. But I see no reason why this shouldn't pass as it's written today through committees. Thank you.
Legislator Bino?
So I've looked up the penal code, and it reads as such: he or she strikes, shoves, kicks, or otherwise subjects such other person to physical contact or attempts to threaten or to do the same. So the attempt to threaten, that's, to me, highly subjective, right? The actual act of an assault, that's not, somebody hurling a bottle or a rock or throwing feces or urine on an officer, that's not subjective. It's clear to me. And then it goes on to say, he or she follows a person in or about a public place or places. And number 3 is probably the part that concerns me the most, is that he or she engages in a course of conduct or repeatedly commits acts which alarm or seriously annoy such other person and which serves no legitimate purpose. So, this bill references the actions that we saw play out across the country as a result of George Floyd's death. There were times when some of the protests turned violent, but there were many times when they were just peaceful protests. And it concerns me that maybe one of those peaceful protests could be considered in number 3 as an action, because it could seriously annoy, right? There were times when it probably was seriously annoying to people that protesters were walking up and down their streets, or that the police felt that they had to monitor that type of activity. I don't want to see at any point in time that where there is no actual physical, attack against a police officer lead someone into a civil court where they don't have the ability to have legal counsel represent them in the event that they cannot afford one. It's that type of language that concerns me. the physical stuff and all the other stuff, I 100% wholeheartedly, support. But the idea that someone just seriously annoying someone is concerning to me. And I think it should concern all of us, quite honestly.
But it sounds, I'm not a lawyer, but it sounds like to me that it would have to be a continuous verbal abuse.
I mean, the penal, I'm looking at the law now. A person is guilty of harassment in the first degree when he or she intentionally and repeatedly harasses another person by following such person in and about a public place or places, or by engaging in a course of conduct, or by repeatedly committing acts which places such person in reasonable fear of physical injury. So, I mean, intentionally and repeatedly. I mean, it's...
So then, let's
So
say
you-
the roads, and I'm asking this.
Sure.
I'm asking, I would like clarification. You're the legal expert, okay? But, well, one of them.
I appreciate that. But
All right, so then in the case, all right, so let's say the Bino brought up, last year, we had protests, okay, as in regard to the George Floyd murder, right? And basically, those in Nassau County were basically peaceful protests, okay? But we also know that while the police officers stood, at attention as everyone passed by, there were comments made to them and whatever. People may have approached up to the officer to say, call them names or whatever. So under this law, the way that you just read it, would that constitute harassment on the part of a person to the police officers? Or is that just something that would be part of a peaceful protest? Because it doesn't seem to be repeated at the same officer. It would just be a group of people continuously shouting something toward a group of officers.
by engaging in a course of conduct or by repeatedly committing acts which place such person in reasonable fear of physical injury. So in my reading, by simply shouting offensive comments that would be offensive to a police officer, no.
Okay.
It wouldn't be.
All right.
You have to put somebody in reasonable fear of physical injury.
So if
Now-
an officer was on patrol and all of a sudden maybe a group of people just surrounded his car, didn't touch it or something, but just started shouting, then that would be something that would fall under this legislation, right? Because the officer may feel that his or her life is in danger because, not that they're touching the car, but the way that they're shouting and constantly menacing.
Is it possible to have a cause of action based upon that fact pattern? Yes, I would think it's possible to have a cause of action, but ultimately it would have to be a jury that would determine whether or not that was reasonable fear of physical
But this would be something that an
And
officer
whether-
then
and-
can
and-
bring action, file an action against those people.
Just because look, there are people that bring actions all the time that are not meritorious causes of action. Ultimately it's up to a jury to determine whether the reasonable fear of physical injury was in fact reasonable, and whether the person who's being accused of committing that intended to have that effect.
Okay. All right, thank you. Legislative Redding.
So I just want to make sure I understand the concern or kind of question, because Legislative Bino, I think you were reading from the New York penal law, right? Okay, and that was for harassment in the second degree, or?
Harassment, let me see. It's New York State Penal Law 240.26, and it's harassment in the second degree.
Second degree. So I guess what I'm trying to understand the concern completely, but like that's the law now.
That's the law for criminal.
Yeah.
For criminal.
Right.
What we're talking about is now a civil
Right.
action, which has a lower threshold for someone to be found,
Right, but
guilty of.
But
and
a
it's
police
for
of-
someone to have to defend themselves.
I understand, but I guess where maybe I'm just not understanding, because right now a police officer could bring a civil action.
No, he cannot. That's the reason why we're bringing this. I asked the question.
What prevents
and
a
I was
police
told-
officer from bringing a civil action now?
Not under the human rights law. They cannot.
Okay, but they can bring a civil suit right now.
Not under the human rights law. And what we're codifying, what we're changing today, would allow for them to bring that civil suit.
Okay, under the human rights law.
That's right.
But they could bring a civil suit now.
Yes,
under a
apparently
different
they
law.
can, but not under the New York, under this. What we would be changing is allowing for it to happen under the human rights law.
Understood. I guess what I'm trying to make the point is, right now, someone can be arrested under the penal law for harassment, for harassing a police officer, and a police officer can bring a civil suit for harassment, perhaps not under the human rights law, but they can do exactly what you're. And maybe I'm wrong.
And so there is
I can defer to some of the much older attorneys to my left, with many more years in experience.
So they're seasoned, those seasoned folks may know this, but I'll state for the record that the other difference here, stark difference, is that law enforcement officer now would be able to collect legal fees from the defendant.
Okay.
So that's a significant difference.
Okay.
And burdensome. So yeah, what I'm trying to do is parse out exactly what the intent is. The intent is that we want to protect our officers. We don't want them attacked. We don't want them to be, subjected to, physical attacks just because they're law enforcement, and to be pummeled and with rocks and stones and that kind of thing. To me, if that's the intent, I think there's too much gray area here, and I think that we're leaving too much opportunity on the table where we could unjustly burden individuals, as Legislator Rhodes stated earlier. It would be litigated, but the person has to have an attorney represent them to litigate this process, and that could be burdensome for individuals, millennials that are out here just trying to express themselves in the middle of a peaceful protest. And I think that there's too much subjective language, and to the extent of what's, seriously, what is in the mind of the individual who feels threatened, just feels threatened. Not that they were assaulted. Those are different animals, right? We should have enough proof to be able to determine if someone has been assaulted. There should be some physical injury. But for someone to only perceive a threat, I think is subjective, and that is the issue that I have today.
Right. Well, just make a point. Our counsel on this over here just indicated that attorney's fees are already recoverable. But I guess that's a difference of interpretation. But in any event, when you're perceived harassment, sometimes you actually may be getting harassed. Sometimes it may just be a misconception. But that's what juries are for, to determine whether the harassment was legitimate. And if there was legitimate harassment, then there's an award given. Again, to me, this bill, which I support, and I appreciate the drafting by Legislator Lafazan, I don't think it actually does that much or changes that much. For me, it's more of a message. It's a message to the residents of Nassau County. It's a message, more importantly, to the state lawmakers, specifically those who represent the constituents of Nassau County, that we value our officers. We put their rights and their protection above the people that are willing to harm them. And it's a message that, in my opinion, needs to be delivered to Albany, and needs to be delivered by this body, because there's not enough bodies sending that message throughout this country or in New York State. So again, I just don't see this as having the effect of what you're suggesting. And again, I think that we can look further into it. And if it's, I understand your concerns. I mean, don't get me wrong. I agree with them. I just don't think that this bill would have that effect.
So there's a fundamental disagreement between our attorneys and yours regarding whether they could get those legal fees. So I'm going to go with the idea that our attorney has stated that legal fees wouldn't ordinarily been recoverable, and if they weren't recoverable, that's a different story. But herein lies the point. You keep, and I just keep trying to go back to the same point. We're talking about young college students, young people that are out there trying to protest, that could be subjected to this law that then says that there was some level of harassment only because there was a perceived threat. We're also saying that could be litigated and they could be found not guilty on the issue, and they could be, the issue could be dismissed or out of civil court. But what we're talking about is the burden for them to be able to pay to go through that process. You know, if it's a criminal case, they can get legal aid if they don't have the money. If it's not a civil case, if it's not a criminal case, and we're talking about a civil case, they have to pay to have a defense, to having a defense attorney act in their interest, and that's, to me, can be a significant burden that one may not be able to recover from. And so therein lies my concern, is that we could be unjustly burdening individuals in a civil case for some subjective situations. When it's flat out that there's some, you know, physical proof that there's been an assault, that's a different story. But when we get here, and I think the intent is to protect our officers, to make sure that they're not getting hurt because there is a willful desire to hurt them because they're law enforcement and they're getting bottles hurled at them. I was under the understanding that was the intent, and if that's the intent, we could still achieve that without putting in some of these penal definitions of harassment and menacing and be more deliberate. And that's my concern here today. I don't think I need to.
Yeah, no, I understand your concerns. I can't speak to the intent. Obviously, I didn't write it, but understood.
Thank you.
Legislative Ina, and you know, we have to protect our officers because they lay there, you know, they're always the front line. But I think from what I gather, you know, from your comments and listening to Legislative Reddy and Legislative Rhodes and Gaylor in regard to the legal aspect, I think that for those that participate in peaceful protests, it seems to me, and I'm not going to say what the intent is, that if it was a peaceful protest and you just had protesters going peacefully, even if they may have been shouting out something, but it was just a matter of like part of the protest, they weren't abusing the officers or throwing anything at them, but just walking down, then I think that would not be the case for any civil action against any of these protesters. I think it's only if all of a sudden they take it upon themselves to start hurling bottles and, you know, whatever, rocks or whatever at the officers or going up to physically hurt them. Am I correct? Legislator, is that the intent?
What I was going to say is, look, I mean, you know, anybody can bring a civil action for anything. But the notion that you're going to find an attorney who's going to bring an action on your behalf as a potential plaintiff on flimsy evidence where you're talking about, you know, simply words that create no reasonable threat of physical harm, I doubt that you're going to get an attorney to bring that case. You know, you can bring a suit for anything, but I believe that this will only be effectively used for cases where you have, you know, actual physical conflict and actual physical injury as a result. But ultimately, a jury's going to have to determine whether or not it's reasonable.
But even sometimes, I mean, we find that even if somebody, like say, a case is brought against somebody under this law, okay, for the intent on civil, that it may not even get to the point where that defendant would have to hire, who's being sued by, say, the officer, may not even get to that where the person would have to hire a lawyer. They may be dismissed outright, saying, well, there is no case for any type of civil action. Am I correct? Or?
I mean, you know,
Madam
you
Chair.
can make. You don't necessarily have to have an look. Or people can act pro se in
Madam
legal
Chair,
proceedings. You
can
can
I-
make a.
Maybe we should just get this either
Yeah, you
through
could-
the committees and have a hearing, or have our attorneys discuss it, because I totally respect what Seal is saying, which is we don't want to have unintended consequences happen. We don't want to, we want to be careful, but I think that we're all in very much agreement of the protections that we want to put into place with the police. So there might be a little fine tuning to meet possibly or possibly not, but I think it should really be discussed with our attorneys and maybe have a hearing after this.
But I guess that the overall
Well taken. Thank you very
point
much,
that I
Russ.
would want to make, Madam Chairwoman, is that, again, this is not creating civil liability or process of civil liability that doesn't already exist. You know, that process takes place, and either we have faith in the civil litigation process, the same as we have faith in the criminal litigation process, or we don't. We haven't changed the process at all. You know, we've simply added a potential cause of action to it for a particular crime.
Thank you very much. All right. No one else? Okay. All those in favor of passing this item, Clerk 187-21, please signify by saying aye. Okay. Any opposed?
On the motion, I'm going to abstain from this vote until I see the amendments to the bill.
Okay.
At this point, I register as an abstention.
Okay. All right. Thank you. All right. So the item passes 6 to 1. 6 with one abstention, right? Okay. Thank you. All right. All right, clerk item number 18821 is a resolution to establish a blue alert system to aid in the identification, location, and apprehension of any individual or individuals suspected of killing or seriously wounding any law enforcement officer. May I have a motion? Moved by Legislator Rhodes and seconded by Legislator Dirigi Whitten. The item is before us. Okay. Okay. The majority filed this amendment on Friday, July 9th, which allows a police commissioner to designate individuals to issue the blue alert and adds police medics and ambulance medical technicians as groups that would trigger the blue alert if harmed or killed. All right. Is there any other comments from any of the legislators on this? Legislator Lafazan.
Thank you, Madam Chair. Last month, I filed the first responder protection package comprised of 2 bills, one which we just voted on, and this bill. I want to thank the majority colleagues for their amendments, which I appreciate and support. Modeled after the Amber Alert system, the Blue Alert system will establish an emergency communication protocol to alert the public of critical information regarding an individual who either seriously injures or kills a cop. This bill, using geolocation to send notifications to all cell phones in Nassau County, as well as utilizing mass communication platforms like television and radio, empowers the police commissioner to send out a blue alert to seek the public's help in apprehending a suspect who targets a police officer and has fled the scene. This bill was sponsored by Assemblyman Steve Stern up in Albany, but is stalled in the state capitol, and obviously they've come home from sessions. So in the meantime, my hope is we pass this bill in Nassau, and then we pass it in Suffolk, creating a Long Island-wide blue alert system from Montauk to Great Neck. But I hope we pass it first, and I thank my colleagues in the majority for their amendments and their support.
Well, I hope they also pass it in New York City. And as Legislator Ferretti says, that we have to send these messages, especially to our representatives and that represent us in Albany and Long Island, that these are the actions that we are taking, you know, in support of our officers as well as many of our first responders as well, you know, because we had added the medics and the ambulance technicians as well. So it is very key, and I'm sorry, it wasn't in my notes that you originally, supported this bill and sponsored it. So I thank you very much for that. Legislator Gala.
Okay, so this is another one I'm supporting, obviously. This, and I don't know if the police department currently utilizes something similar to this, which we're codifying basically, but the Stop and Shop incident in West Hempstead, which affected many of our districts on this end of the county, is a classic example where we had an active shooter situation that played out over time. The police commissioner absolutely needs to have the ability to initiate some kind of blue alert system to let all of our residents, using the latest technologies and geo technology tied to phones and whatnot, and sending reverse 911 notices to cell phones. So I think this is a great item before us. So again, thank you, Legislator Lafazan, for getting it started, and I thank my fellow colleagues for tweaking it, amending it, and making it even better. And you have my full support on this one.
Anyone else? Okay. All those in favor of passing this item, please signify by saying aye. Any opposed? None? All right, the item passes unanimously. All right. Clerk, item number, let me see, 226 is an ordinance supplemental to an appropriation ordinance in connection with the Office of the Medical Examiner. I'm also going to, I think, call item number 238-21, which is also a supplemental ordinance in appropriation with the Office of the Medical Examiner, as well as item 242-21. Same thing with the medical examiner. Okay. So I may have a motion moved by Legislator Gaylor, seconded by Legislator Ferretti. These items are before us. I'm calling all three, if that's okay.
Terrific.
Okay?
Thank you very much. Okay. My name's Carolyn Kelly. I'm the Deputy Medical Examiner for Laboratories. The first item, 226-21, is to supplementally appropriate funds to the department. This is grant funding. It's from the New York State Division of Criminal Justice Services. It's the Aid to Labs grant in the amount of $102,108. This will have no net impact on the budget since it's an equal amount of expenditure and revenue. So this is just a pass-through. Are there any questions with that, or should I proceed to item 238?
We'll have a read all three, and then if there's
Okay.
any questions, all right? Thank you.
Item 238-21 is also a proposed ordinance to supplementally appropriate funds into the department. This is from the New York State Division of Criminal Justice Services. It's the Paul Coverdell grant, it's also similar to the Aid to Labs grant. This one is for the amount of $57,211. Again, this is to assist toxicology lab, which is under the umbrella of the medical examiner's office, with their operations. Again, it will have no net impact on the budget, and it recognizes an equal amount of revenue and expenditure. The final item is 242-21. Again, this is a proposed ordinance to supplementally appropriate funds into the department. This is the New York State Highway Traffic Safety Grant. It's in the amount of $35,000, again, for the toxicology lab to aid them in their human performance testing, which is drunk driving cases and drugged driving cases. The supplemental appropriations will have no net impact on the budget since, again, it recognizes an equal amount of revenue and expenditure.
Any questions? I see none. Okay, so voting on to move items 226-21, 238-21, 242-21. All those in favor of passing these items, please signify by saying aye. Any opposed? Okay, the items pass unanimously. Thank you very much.
Thank you very much.
Okay. Sorry. All right, clerk, item 239-21 is an ordinance supplemental to an appropriation ordinance in connection with the district attorney. May I have a motion? Moved by Legislator Bino, seconded by Legislator Ferretti. Okay. Good afternoon, sir.
Good afternoon. Bob McManus, District Attorney's Office. This item before you is a supplemental appropriation for the gun-involved violence elimination grant awarded to the District Attorney's Office by the New York State Division of Criminal Justice Services. This program employs a variety of strategies to reduce gun violence. Other recipients of funding include the Nassau County Police Department, the Sheriff's Office, the Probation Department, the Hempstead Police Department, as well as the District Attorney's Office.
Thank you. Any questions from the legislators? I see none. Okay. All those in favor of passing this item, please signify by saying aye. Any opposed? All right, the item passes unanimously. Thank you very much, sir.
Thank you.
Okay. All right, clerk, item number 240-21 is an ordinance supplemental to an appropriation ordinance in connection with the police department. May I have a motion? Moved by Legislator Rhodes, seconded by Legislator Gaylor. Good afternoon.
Good afternoon, William Field, Inspector with the Police Department. Item 241-21 is an appropriation of $209,090.90 in funds received from the New York State Office of Homeland Security. The funding will be utilized for the purchase of equipment and training to enhance our arson and bomb squads regarding explosive device response operations.
Okay, all right. Any questions from the legislators? Okay, I see none. All those in favor of passing this item, please signify by saying aye. Any opposed? The item passes unanimously. Thank you very much.
Thank you.
Okay. Sorry, just bear with me, I'm sorry. Okay. Clerk item number 241-21 is an ordinance supplemental to an appropriation ordinance in connection with the Office of Emergency Management. May I have a motion? Moved by Legislator Georgie Whitten, seconded by Legislator Freddy. The item is before us. Good afternoon, sir.
Thomas Delaney, Office of Emergency Management. This is a $123,000 grant award from New York State Homeland Security. It's called Public Safety Answering Point. We're going to use it to enhance our capabilities at the 911 Center.
Very timely, considering that we're probably going to have a busy hurricane season, right? All right, thank you. Any questions for any of the legislators? See none? All right, all those in favor of passing this item, please signify by saying aye. Any opposed? All right, the item passes unanimously. Thank you very much. Okay. All right. Okay. There is one item on the addendum. May I have a motion to suspend the rules? Moved by Legislator Gaylor, seconded by Legislator Rhodes. Any debate or discussion? No. Okay. So the rules are suspended. There's one item on the addendum, which is clerk item number 263-21, a local law to amend the Nassau County Administrative Code to prohibit the refusal to serve first responders. May I have a motion? Moved by Legislator Gaylor, seconded by Legislator Georgie Whitten. This item is now before the committee. Over the past few years, there have been instances throughout the United States where police officers have not been served at restaurants, coffee shops, and retailers due to their police officer status. Both business and rogue employees have participated in such behavior. Police officers protect and serve their communities, including businesses, and respond to assist businesses when they are either the victim of a crime or there is an altercation within the stores. Often these officers jeopardize their own safety and well-being when responding to calls for assistance. This anti-police behavior by business or rogue employees is abhorrent and unacceptable. Accordingly, the purpose of this legislation is to prohibit businesses or employees from refusing to serve an individual due to his or her first responder status. All first responders are included in this legislation as their daily actions allow residents to live freely and peacefully. However, businesses shall not be liable when their employees violate this proposed local law without being directed to do so, and an employee is not liable when directed by a business to violate the law. A violation of this proposed local law is punishable by a civil penalty not exceeding $1,000. Any debate or discussion? No? Okay. Any public comment? Okay. All those in favor of passing this item, please signify by saying aye. Aye. Any opposed? Okay. The item passes unanimously. There is no business in front of this committee. May I have a motion? No further other business, I'm sorry. May I have a motion to adjourn? Moved by Legislator Gaylor, seconded by Legislator Bino. All those in favor? This committee is now adjourned. Thank you, everybody. Health Committee will be next.
At this time, I will call the Health and Social Services Committee to order and ask the clerk to take the roll.
Thank you, Madam. Health and Social Service Committee, roll call. Legislator Joshua Lafazan.
I'm subbing in for Josh.
Okay, thank you, Ms. Muley. Substituting for Legislator Arnold Drucker would be Legislator Birnbaum.
Here.
Thank you. Ranking Member Delia DeRicci-Whitten. Legislator C. William Gaylor III.
Present.
Substituting for Legislator Laura Schaefer, Legislator McKevitt.
Here.
Thank you. Vice Chairman James Kennedy.
Here.
Chairwoman Rosemary Walker.
Here.
We have a quorum, ma'am.
Thank you. Okay, we have 3 items on the agenda today, which are clerk items number 223-21, 224-21, and 225-21. Clerk item 223-21 is a local law to amend the Nassau County Administrative Code to create a special revenue fund to assist Nassau County to combat the opioid epidemic. May I have a motion, please, by Legislator Kennedy, seconded by Legislator DeRicci-Whitten. The item is before us, and this local law is to establish this special revenue fund so that any of the monies that we collect from the opioid settlements will go into the special revenue fund and will be used to fight the opioid epidemic, whether it be used educationally, in prevention, into treatment, whatever ways best used, but it will be a special revenue fund set up, and the monies will only go towards fighting the opioid epidemic. Does anybody else want to add anything to that?
I'm happy that we're doing this, so I think it's a very good idea. I think, this whole opioid crisis has cost the county so much, not only financially, but emotionally, and I'm really glad these companies are paying a little bit. They made so much money off of this crisis, so the whole thing, I think, is very positive, so thank you.
Thank you. I totally agree, and it's sad because as we were making headways, unfortunately, due to COVID, we've really had a setback in fighting that opioid epidemic, and I could tell you I know personally a number of people that did overdose and pass away during that time, and many others are fighting to keep moving forward. So, if Legislator Gaylor?
Sure, absolutely, and thank you, Madam Chairwoman. So, again, I've got my support on this one. This is another example where I think we have to do more at our local level, county level, because the state continues to fail us. And, we understand that marijuana is a gateway drug to opioid use, yet the state, state representatives let us down by voting in favor of passing the marijuana law. So, this is just the right thing to do. The opioid epidemic is with us. It's amongst us. It affects us in our communities. It affects me in my district, our youth, and we work well with the Rockville Center Coalition for Youth, and there have been numerous overdoses over the last 2 years in our district that this bill will hopefully help to prevent in the future. So, thank you for introducing it. Thank you for allowing me to say a few words, and you've got my support.
Thank you, Legislator Gaylor. Legislator Kennedy?
Thank you, Legislator Walker. Yeah, I'd just like to say that I'm 100% behind this. Obviously, my support is there. I just want to say that we've seen over the course of the last 15, 16 months, this pandemic has caused tremendous stress on so many people. And I think that maybe sometimes it hasn't been talked about just how much people have been impacted, and in ways that we don't even know yet. And I think that it's so important. And I have organizations in my district, Massapequa Takes Action Coalition, the Yes Community Counseling Center, Drug Free Long Island, so many groups that are doing so many good things. And I'm just so happy that we can that people can get the help that they need, and that they continue on a path towards success, and that they can really benefit from this, and we can really help people, because that's the bottom line. That's it. Thank you, Legislator Walker.
Thank you, Legislator Kennedy. Anyone? Legislator Birnbaum?
Thank you for this opportunity. I mean, it's just fortunate that I'm subbing today in this committee, and I'm listening to and hearing the statistics about the overdosing and how it increased during COVID, but it's as timely as ever because we're about to settle some major lawsuits with the manufacturers of these opioids, so we need to have a fund in place and do whatever the county can do as an entity to combat the opioid epidemic. So thank you.
Thank you, Legislator Birnbaum. And Legislator Muley.
Thank you, Madam Chair. I too fully support this. And I was glad to hear in your opening remarks that it would not just be used for treatment, but that it would also be used for prevention. Because I think that's incredibly important. But my question is this: how will it be determined what agencies will be getting the money? Like, what will be the criteria? Has that been determined, and who will make those decisions?
I believe that is something that we still really need to work out and make sure that it's going to the best places possible, and certainly for the best education possible. So we will continue to be working on that. But it was very important to set up this designated revenue source so that the monies, once these settlements are done, that they go right into it, not waiting for them to happen, and then all of a sudden, you know, we're kind of hurrying and trying to rush to put something together.
Oh, I agree completely. Will that be something that will be a possible amendment, or will that be something maybe the administration will be deciding? How is that going to happen?
One sec.
Mm-hmm.
Kind of what I was saying before, that we can certainly from the executive offices, from the legislature, and even from our departmental offices to see what the best route is for us to move forward on that. But those that have not been established yet.
Thank you.
Any other legislators have any comment or questions, any public comment? Sorry, could you get those before? Do I need to repeat it? Okay, good. All right. Clerk, item 224-21 is an ordinance supplemental to the annual appropriation ordinance in connection with the Health Department. And we have Ms. Mary Ellen Lorraine. Want me to call the other one also?
Sure.
And clerk, item 225-21.
Good
which is an
afternoon,
ordinance
Mary.
supplemental to the annual appropriation in connection with the Health Department.
Good evening, Mary Ellen Lorraine, Department of Health. Item 224-21 is a supplemental appropriation.
I'm sorry, we didn't have a motion for these. By Legislator Gaylor, seconded by Legislator Muley.
Item 224-21 is a supplemental appropriation. It's in the amount of $93,750. This is for our sexually transmitted disease program. It is funded through New York State Department of Health, and its mission is to prevent the spread of sexually transmitted diseases through identification, treatment, and contact investigations. Item 225-21 is a supplemental appropriation. It's in the amount of $118,144. It's for the Children with Special Health Care Needs program. This is funded through New York State Department of Health. It provides information and referral to families of children who are under the age of 21 who have a special need. It provides information and referral.
Any questions from the legislators? Any comments? Any public comment? Hearing none, all those in favor of clerk items 224 and 225-21 signify by saying aye. Any opposed? Any abstentions? Then they too will move on to finance.
Thank you.
And while you are there, I just want to thank you for the update.
There'll be more tomorrow.
We are keeping you extremely busy. You kind of just came off the real craziness of COVID just into another craziness. So thank you very much for all you do. There's no other business before us. A motion to adjourn by Legislator Gaylor, seconded by Legislator Brembaum. All in favor signify by saying aye. Okay, they were adjourned, and the next committee is Minority Affairs.
And at this time, we'll call the Minority Affairs Committee to order, and we'll ask the clerk to call the roll.
Thank you, Chairman. Minority Affairs Committee, Legislator Deborah Muley, Minority Leader Kavan Abrahams.
I'm sorry, Mr. Pulitzer. I believe Legislator Bino may substitute for me in light of to be able to talk about her bill a little bit more extensively.
Thank you, will do.
So I apologize. If you could just come back to me, we'll have it resolved.
Will do.
In the next 10, 15 seconds.
Legislator Denise Ford, Ranking Member.
Minority Leader Abrams, if it makes it easier for you, I have no objection if she would like to speak to her bill without actually being on the committee. Okay.
Okay. Ranking Member Carrier Solage.
Here.
Thank you. Legislator Denise Ford. Legislator James Kennedy. Vice Chairman Rosemary Walker. Chairman Stephen Rhodes. We have a quorum, sir.
Thank you, Mr. Clerk. There is one item on the main agenda today, and we also have an addendum item as well. That's Clerk Item Number 217-21, which is an ordinance amending Ordinance Number 543-1995 as amended by Ordinance Number 243-1999 to add June 19th, known as Juneteenth, to the list of compensated holidays for Nassau County ordinance officers and employees. Do we have a motion? So moved by Minority Leader Abrams and seconded by Legislator Walker. That item is now before us. Do we have someone to speak on the item? And we'll recognize Legislator Bino.
Thank you, Chairman Rhodes. So the bill is, stated that, we want to acknowledge the Juneteenth holiday as a highly significant day in American history, marking the commemorating date of June 19, 1865, the day the Union General Gordon Granger issued his famous General Order Number 3, bringing news to the President Lincoln's Emancipation Proclamation to the people of Texas. This is an opportunity for Juneteenth to be looked at as a milestone in our quest to realize for all Americans the ideals of human equality and dignity enshrined in the Declaration of the Independence. and in the Constitution of the United States and the state of New York. This is an opportunity for us to reflect and be recommitted to our constitutional ideals. And that is the purpose of and the intent of this particular piece of legislation.
Thank you, Legislator Bynum. And is anyone here from the administration to speak with respect to the bill? No? Okay, fantastic. Do we have comments from other legislators? Seeing none, is there any public comment? All right, we'll move to a vote. All those in favor of clerk item number 217-21, please signify so by saying aye. Those opposed say nay. The item carries and is referred to rules. We do have one item on the addendum. I need to suspend rules or anything, right? Oh. So I'll entertain at this time a motion to suspend the rules. That motion is made by Legislator Walker. It's seconded by Legislator Solage. All those in favor of suspending the rules, please signify so by saying aye. Those opposed say nay. Rules are suspended. So we have clerk item number 259-21, which is a local law to require the county to engage in prompt collective bargaining regarding additions to the schedule of county holidays. And that is moved by Legislator Muley and seconded by Legislator Kennedy. That item is now before us. And do we have, who would like to speak on the amendment? I know what it's about, but Legislator Bynum.
Okay, thank you. I think you really clearly stated the intent of this particular local law. It is for the purpose of requiring prompt negotiations with unions as it relates to any additional holidays that would be recognized by the county. The previous bill was to provide the holiday to ordinance workers, where we have the right to do so. And in this particular bill, it allows for the negotiations with our unions by, many different means that are available to them to provide this holiday to all of the union employees.
Thank you, Legislator Bynum. And I would offer potentially one suggestion, in that I think we would happily vote to amend the original bill before we consider it before the full legislature, to include the collective bargaining provision rather than pass separate bills. But however you want to handle it is fine. I don't think you'll have any objection on our end. If I could just ask, is there anybody here from the administration to speak with respect to this item? Katie, if you can come up. Is Katie here? Hi, how are you? Thank you, Katie. Just on behalf of the administration, do we anticipate, obviously, the bill is going to pass the full legislature in 3 weeks. I would anticipate that the administration will engage in negotiations with the various unions quickly.
As you know, I'm not involved in labor negotiations. All I can say is that the bill is under review by the administration. That's all I have at the moment.
Do you foresee any possibility that any union would somehow oppose the receipt of an additional holiday?
You'd have to ask them. I can't speak for them.
But can the administration commit to aggressively engaging the unions to resolve this outstanding issue? We're not going to have this dragging on for a lengthy period of time, I would expect, right?
Like I said, I'm not involved in labor negotiations, and they can be lengthy, but we will do our best.
Do you foresee there being any issues with respect to this bill?
I'm not involved in labor negotiations. I can't say yes or no.
And I assume that there's no one here from the administration with respect to labor negotiations, right?
No.
Okay. Thank you. Do any other legislators wish to be heard? And do we have any public comment? All right, we'll move to a vote. All those in favor of clerk item number 259-21, please signify so by saying aye. Those opposed say nay. The item is agreed to and is referred to rules. At this point, there is no further business for the committee to conduct. I'll entertain a motion to adjourn. Moved by legislator Walker, seconded by legislator Ford. All those in favor of adjourning, please signify so by saying aye. Those opposed say nay. We stand adjourned. Next up, I believe, is veterans.
At this time, I'd like to call the Veterans and Senior Affairs Committee to order. I'll ask the clerk to call the roll.
Thank you, Chairman. Veterans and Senior Affairs Committee, Legislator Ellen Birnbaum,
Here.
Legislator Delia Georgi-Witten, Ranking Member Debbie Muley, Legislator Stephen Rhodes, Legislator Rosemarie Walker, Vice Chairman C. William Gaylord III, Chairman John Ferretti.
I'm here.
We have a quorum, sir.
Thank you, Mr. Clerk. There's one item on the agenda today, which is clerk item number 244-21. Clerk item number 244-21 is an ordinance to amend Section 2 of Ordinance 73-2014 to extend to members of the active military, reserves, and National Guard the discounts to facilities and activities of the Department of Parks, Recreation, and Museums that are currently provided to veterans. May I have a motion?
So moved.
Moved by legislator Gaylor, seconded by legislator Rhodes. The item is before us. Who is here from the administration to speak about this item?
Victoria Queso from the Department of Parks. So 244 is an ordinance amending ordinance number 73/2014, Section 2 as amended, to provide our active military, reserves, and National Guard discounts in acknowledgement of their service for various parks activities and services by including them within the definition of veterans. All of these individuals entitled to these discounts would present their common access card to receive the available discounts.
Okay. Legislator Gaylor.
Thank you.
And thank you.
Thank you, Chairman Ferretti. Good evening. Yeah, good evening, 6 o'clock. Could you just tell me what does it mean, active military reserves and National Guard? How is that defined?
Good afternoon, Legislator Dennis McDermott, Deputy County Attorney.
Hi, Dennis.
How are you doing today,
Good.
sir? The definitions for active military are anyone who has use of the Common Access Card, and the National Guard and Reserve, they're using the state definitions. And
so I'm just want to get some clarification. So this would include all active military. Would it include retired military, such as myself, who has a retired military, Department of Defense
Yes, it
card? Okay. Would it include those active Reserve and National Guard members that have been called to active duty status?
yes, it would.
And would it also include those that are not currently on active status? They have a CAC card. They have a DOD.
I believe the intention was that they would be included.
Okay, so it's anybody who has a Department of
CAC card.
Defense CAC card or some other form of
Correct.
retired identification is covered. Okay. What about plain old veterans that have gone down to the Nassau County Clerk's office, registered their DD Form 214, were issued by the county clerk a veterans card?
Well, the veterans are already covered under
Okay.
this ordinance.
Gotcha. So this is just a
This
tweak.
is just adding the
a tweak on the
active
2014 bill. Okay.
Correct.
Got it. Thank you very much, Dennis.
Thank you.
Okay, any further debated discussion? Oh, Legislator Rhodes.
Thank you, Chairman Ferretti. My understanding is, and I got a couple of emails on this, that the Parks Department for active duty military was actually already offering free admission, not discounted admission, but free admission to active duty military. This bill that's been submitted by the administration indicates discounted. So I want to make sure that while I'm fully in favor of expanding the definition, I don't want to be taking away effectively a benefit to active duty military.
Good evening, legislator. Yes, the active military and the families have been receiving total waivers of fees on certain things, such as pools, but they haven't really been receiving discounts on many other things. It was the intent of the administration that those activities where they already are having their fee waived, that would continue, and it would only be discounts for things that they are not currently receiving any break on.
But that's not what the legislation says. So perhaps in between committees and the full session, we should break out what's free and what's discounted?
And that could be done.
All right, thank you.
Well, Legislator Gaylor.
So, Dennis, don't run away. All right. So maybe between now and the full ledge, we can make it so that anybody serving active duty right now is exempt from any fee for anywhere in any county park, and then discount the rest. That's what I would like to see.
We will bring it back to the administration.
Thank you.
Should I stay?
Maybe. Legislator Birnbaum.
Yeah, now I'm a little confused because I thought this bill was to add these privileges to the military, reserves, and National Guard, the same exact privileges that are provided to veterans. So we just have to make it equal. So whatever veterans are getting, they're getting as well. They all have to be the same, right?
I do believe that an ordinance can make different differentiations between active military and veterans. I don't know if Legislator Gaylor wants additional preferences, I guess, for the active military as opposed to veterans. But that's really, I believe, the administration and the legislature, would have to come to some meeting of the minds as to exactly what discounts and how much would be available.
Well, I'm not sure what the intent was, because to me it sounds like they should all be equal.
Well, the intent as drafted was to give the active military the discounts that the veterans are receiving now and the active military are not, but to continue with the waivers for those certain activities that the active military is currently receiving.
Let me ask, I think Legislator Birnbaum's question may be best answered by maybe Katie, or is there, it sounds like you're asking the intent of the bill, right? I mean, that's an administration bill, so maybe they can, sorry, Katie, put you on the spot.
It's all right. Katie Horst from the administration. Yes, Legislator Birnbaum, you are correct. I'm sorry, I can't see you. The intent was to include the active and the reserves with what the veterans were already receiving. As to Legislator Gaylor's point that he brought up, I will absolutely bring it back and get the administration's opinion on it.
Okay, any further debate or discussion? Do we have any public comment? Okay, there being none, all those in favor of passing this item, please signify by saying aye.
Aye.
Those opposed, passes unanimously. There's no other business in front of this committee. May I have a motion to adjourn? Moved by Legislator Birnbaum, second by Legislator DeRiggi Whitten. All those in favor? Aye. Those opposed? The committee is now adjourned. And Finance is next.
Okay, do we have the members of the Finance Committee all seated? Excellent. Mr. Pulitzer, would you be so kind as to do the honors?
Thank you, Chairman.
Thank you.
Finance Committee roll call. Legislator Joshua Lafazan. Legislator Lafazan. We'll come back to. Legislator Arnold Drucker is absent.
I'm going to be substituting for him, Michael.
I'm sorry?
I'm going to substitute for Legislator Drucker,
Thank you. That's Legislator Delia DeRicci-Whitten.
and I'm here.
And you're here. Okay. Ranking Member Ellen Birnbaum.
Here.
Thank you. Legislator Rosemary Walker. Legislator Thomas McKevitt. Vice Chairman, substituting for the Vice Chairman Vincent Muscarello will be Legislator Stephen Rhodes. Thank you. Chairman Howard Copel.
And I'm here.
We have a quorum, sir.
Thank you. Okay, we'll start with a number of items that have passed through some previous committees unanimously, and it's been determined by the majority minority that these do not require any further debate or discussion. So I'm going to call them together first to start out, and that would be number 223, 224, 225, 226, 238, 239, 240, 241, 242, 244, and that's it. All those in favor of passing these items, please so indicate by saying aye. Any opposed? Those items pass unanimously. We need a motion, don't we? Yes. Okay, that motion on those items is made by Legislator Birnbaum, seconded by Legislator DeRicci-Whitten. All those, try that again, all those in favor once again? Aye. Any opposed? Okay, those items are unanimous. Thank you. Okay. We're going to call 227, 228, 229, and 230 together. Those are supplemental appropriations, and motion is made by Mr. McKevitt, seconded by Ms. Walker.
Thank you, Legislator. Kevin Crean, Office of Community Development. Items 227, 228, 229, and 230, as indicated, are supplemental appropriations to the office. These are all federal funds from the U.S. Department of Housing and Urban Development. The first one is home funding, a supplemental appropriation of home funds under the American Rescue Plan. The other three are regular entitlement grant from the U.S. Department of Housing and Urban Development. Generally, those funds are considered consolidated program funds. Those funds were included in the annual action plan that was approved by the legislature on June 28th.
Okay, any questions? Okay, hearing none, all those in favor, please so indicate by saying aye. Any opposed? Those items are unanimous. Thank you, sir.
Thank you very much.
Number 231 is a transfer of appropriations. Motion by Mr. Drucker's not here. By Ms. Walker, seconded by Ms. Birnbaum.
Good evening, Mary Ellen Lorraine, Department of Health. Item 231-21 is a board transfer in the amount of $4,883. This is for grant-funded programs. It has no impact on the budget, and it's to maximize grant reimbursement.
Okay, do we have any questions? Okay, all those in favor, please so indicate by saying aye. Any opposed? That item's unanimous. Do you have any others?
Yes, I have 232, 233, 235, and 236.
Well, keep on going.
Okay.
Please.
232-21
Which is a one. Let me call them first, okay? So we're talking 232, 233,
235, and 236.
235 and 236, all transfers of appropriation. There's a motion by Ms. Walker, seconded by Mr. Ritchie-Whitten. All right, go ahead, please.
232-21 is a board transfer in the amount of $18,296. Again, this is for a New York State Department of Health grant fund. No impact on the budget. It's to maximize grant reimbursement. 233-21 is also a board transfer. Actually, it's two. One is for $10,000. One is for $5,000. Again, it's for our New York State grant-funded program. No impact on the budget, and it's to maximize grant reimbursement. 235-21 is a board transfer in the amount of $973. Again, it's a New York State Department of Health grant-funded program to maximize grant reimbursement. No impact on the budget. Item 236-21 is a board transfer in the amount of $5,663. Also a New York State Department of Health funded program. No impact on the budget.
Okay, do we have any questions? Okay, all those in favor, please so indicate by saying aye. Any opposed? Those items are unanimous. Thank you.
Thank you.
234 is another transfer of appropriations. And motions by Mr. McKevitt and seconded by Ms. Birnbaum.
Good evening. Larry Nadelka from the Board of Elections. This transfer is to help us cover a $14,000 portion of our trucking bill from last general election. Because of the COVID restrictions and changes to the election law, we had a larger trucking expense with additional requirements from what was originally budgeted. We accrued the money earlier this year, and then by the time we got the process in, since you're now doing quarterly transfers, this was the earliest that we could get it in. So this is just the balance of that expense from last year, and we should be okay for the rest of this year with our current allocation.
All right. Any questions? All those in favor, please say aye. Any opposed? Have you anything else? That's
No, sir.
unanimous. Thank you. I'm sorry?
No, sir.
No.
That's it.
Okay. Thank you. So 243, another transfer of appropriations. Once again, motion by Mr. Reggie Whitten, seconded by Mr. McKevitt.
Captain Michael Golio of the Sheriff's Department. This is a board transfer of $280,000 of asset forfeiture funds to our equipment line. Transfers have no impact on the overall budget, and it represents the transfer of existing funds.
Any questions? Okay, all those in favor, please say aye. Any opposed? That item's unanimous. Thank you. Number 254 is another transfer of appropriations. Motion by Ms. Walker, seconded by Ms. Birnbaum. Anyone here on that item? 254. That's actually a majority item for transfer of appropriations within the majority budget. Do we have any questions on that? Hearing none, all those in favor, please say aye. Any opposed? That item is unanimous. Give me a moment. Okay, 247 is a resolution to correct certain erroneous assessments. Motion by Mr. McKevitt, seconded by Mr. Reggie Whitten.
Good evening. Dan Ross, Nassau County Department of Assessment. We are here requesting this resolution to be passed today to restore these properties to the tax-exempt portion of the roll. These properties either did not file in a timely fashion or did not renew in a timely fashion, so we need now to restore them to their tax-exempt portion of the tax roll.
And I see you've got a bunch on the addendum as well, right?
Correct.
So then stick around. First of all, let's vote on 247. All those in favor? Aye. Any opposed? Okay. That item is unanimous. Thank you. Now, Ms. Birnbaum moves to suspend the rules, and seconded by Ms. Walker. All those in favor of suspending the rules? Aye. Any opposed? Okay. The rules are suspended. Now, let me call number 256, 257, 258, 260, 261, and 262, all of which are related to settling tax issues. Those are yours, right?
Not 260, I don't believe, no.
Okay, let's take 260 off that. So all those except for 260. Motion by Ms. Walker, seconded by Ms. Birnbaum. Same thing?
It's the same exact issue. These are all wholly exempt properties, nonprofits or religious organizations that have either missed the renewal or did not file for the first time in time, and we're here to restore them to the tax exempt portion of the tax roll.
All right, any questions? Hearing none, all those in favor, please say aye. Any opposed? Okay, those items are all unanimous. Thank you.
Thank you.
Number 255 is a transfer of appropriations. That motion is by Ms. Walker, seconded by Mr. McKevitt. Andy?
Good afternoon, Andy Persico, Office of Management and Budget. This item is a board transfer between different funds in the county. It's just realigning some of the budget items that we had shortfalls in from excess funds that we had throughout different departments.
Okay. Any questions? All those in favor, please say aye. Any opposed? Okay, thank you.
Thank you.
We have a number of items remaining, all of which are going to require going into executive session. I'll call them together. And those would be numbers 220, 221, 222, 237, 245, 246, and 249. Motion on those items is made by Mr. McKevitt, seconded by Ms. Birnbaum. And now I'll take a motion for executive session made by Ms. Birnbaum and seconded by Mr. McKevitt. All those in favor of going into executive session, please say aye. Okay, any opposed? We're in executive session. Members of the Rules Committee are invited to join us as well.
How would guys want to do it from the August room or remotely? So.
One more item for executive session. That's 260, and motion is made by Ms. Walker, seconded by Ms. DeRigi-Witten, even though she's not in the room. Thank you. Okay, one. Yeah, I know that. Andy, one question, one quick question on just one of them for the on number 249, and that's the Keyspan case. Where would the money come from?
What my plan is I might have some excess funds in the operating budget and the judgments and claims. As a backstop, I have money in the litigation fund that I'll be able to use to fund it if I can't find, savings in the operating budget.
Okay, I just we're going to vote on this now, but can you try to have more detail for us at the full edge?
Sure,
please?
absolutely.
Because this might be a matter of discussion.
Understood, but
Okay.
do realize I have a pot of money in the litigation fund that I can dip into if I need to. It's about $14 million,
Yeah,
and I
but
have some
if
other
you dip
savings.
into that now, then you don't have it later.
If I don't spend, I have to come to you to spend it first, so that would be the whole thing. So
Yeah.
I need you
Okay.
I need you to appropriate it, and any type of movement I would do would require legislative action,
All right.
so.
Okay, thanks.
No problem.
Okay, all those in favor of all of the items, you have the items? Okay, for which we just went into executive session. All those in favor of these items, please so indicate by saying aye. Any opposed? Okay. Mr. McKevitt would like to adjourn. He's got his, he's already standing with his briefcase. And that's seconded by Mr. Reggie Whitten. All those in favor of adjourning, please say aye. Aye. Any opposed? We are adjourned. We're back to rules. No, rules.
Oh, I didn't see him in the room.
Yeah, he was there.
He was there?
Yeah, he was there. So you heard what I told us. Yeah.
I'm calling the Rules Committee out of recess. We have before we do anything, we need a motion to suspend the rules. Moved by Legislator Rhodes, seconded by Legislator Bino. All in favor of suspending the rules signify by saying aye. Aye. Those opposed, the rules are suspended. All right, we're going to call the consent calendar first. These went through other committees earlier. It's been agreed by the majority and minority that no further debate or discussion is needed at this time on these items. 188, 2021 is all 2021. 2017, I'm sorry, that was 217. 220, 221, 222, 223, 224, 225, 226, 227, 228, 229, 230, 231, 232, 233, 234, 235, 236, 237, 238, 239, 240, 241, 242, 243, 244, 245, 246, 247, and 254. 255, 256, 257, 258, 259, 260, 261, 262, 263, and last but not least, 249. Any debate or discussion? All in favor signify by saying aye. Those opposed? Those items carry unanimously. Oh, thank you very much. Motion by Minority Leader Abrahams, seconded by Deputy Presiding Officer Coppell, for the record. And again, they passed unanimously. 187 of 2021 is a local law to amend the Nassau County Administrative Code in relation to amending the Nassau County Human Rights Law to preclude discrimination against first responders. Moved by Legislator Rhodes, seconded by Deputy Presiding Officer Coppell. Any debate or discussion at this time?
No further debate or discussion, Presiding Officer, but as I concur with my colleague, Legislator Bino, I think I would like to hear a little bit more in regards to the bill, and hopefully over the next 2 weeks we'll be able to refine it for something that truly protects police officers, but at the same time doesn't damper or pretend to chill any First Amendment rights as well. So I look forward to that discussion over the next 2 weeks as we enter the hearing process.
Okay, that sounds good. Any other debated discussion? All in favor, signify by saying aye. Those opposed? And 2 abstentions. Okay, so it passes by a vote of 5 in favor with 2 abstentions. Next item is 218 of 2021. It's a resolution to establish the Special Legislative Task Force to combat anti-Semitism. Moved by Minority Leader Abraham, seconded by Legislator Ford. Do you want to say a few words?
Sure. I mean, as we know, Legislator Drucker was not able to be here today, but he did ask me to share some comments about his particular legislation. As many of you know, from reading the bill, this legislation would establish a special task force to combat anti-Semitism in Nassau County. We've all seen the anti-Semitism that has existed, not just here in our county, but across our nation. This bill would establish a special task force to be able to combat anti-Semitism. It would consist of 6 legislators, 3 appointed by the Nassau County Legislature's presiding officer and 3 chosen by the minority leader. The county executive has expressed support in terms of the working definition of anti-Semitism in order to combat it. So I think from that standpoint, it's all heading in the right direction. And then the last thing that I think is most notable that Legislator Drucker was able to accomplish in this bill, it will allow a youth roundtable also to be a part of the discussion to lead to anti-Semitism as well. So all in all, even though this is in the committee process, I encourage my colleagues to support this tremendous and great bill and look forward to supporting it in the full legislature as well. Thank you.
Is there any further debate or discussion? We good? Hearing none, all in favor signify by saying aye. Those opposed? It carries unanimously. Let's see. I believe it's the last item. It's on page 5 of the agenda. It's 248 of 2021. A resolution to accept a gift offered by the Nassau County Council, Veterans of Foreign Wars, to the Nassau County Department of Parks, Recreation, and Museums to enter into an agreement in relation to such gift. Who haven't I gotten? Moved by Legislator DeRiggi Whitten, seconded by Deputy Presiding Officer Copel. Thank you.
Victoria Queso, Department of Parks. 248 is a resolution to accept a gift from the Nassau County Council of Veterans of Foreign Wars. If passed, to honor those that served in the Afghanistan and Iraq wars, if passed this, the resolution, the county will enter into a gift agreement with the VFW, who will form an advisory committee to work with the county in establishing a new monument at Eisenhower Park to honor veterans of the wars in Afghanistan and Iraq and raise money for its design and commission. Members of the advisory committee will be appointed by the county executive, director of the VSA, majority and minority of the legislature, and that's it. And we anticipate breaking ground at Eisenhower Park on October 7th of 2021, which will mark the 20th anniversary of the beginning of the war in Afghanistan.
Okay, any other debate or discussion? Thank you very much for the presentation. All in favor signify by saying aye. Those opposed, it carries unanimously. Motion to adjourn by Legislator Rhodes, seconded by Legislator Ford. All in favor of adjourning signify by saying aye. Aye. Those opposed, we're adjourned. Thank you.
you.